folks, and welcome back. It is Wednesday, and it's a recap until trial goes live today. We are starting off with Monday, the afternoon, then the entirety of Tuesday, which is not as bad as it sounds. It was a grand total of 90 minutes yesterday, an hour and a half. Yeah. And then if we time it correctly, we will go right into today's live stream or directly from the court, as they are scheduled to start at 1:30 p.m. scheduled. But we do know this judge and being on time. All right, that and more on today's show. Welcome. All right, yeah. I thought we would get right into this. I hope you don't mind. Let's see here. Mr. Jingles. First, to cover the law and C word. This is directly after lunch Monday, and it is the cross-examine. We are starting with the rebuttal from Miss Hilton or Miss Love. I don't know. I don't remember which one of them it is. Hey, Sal. Hey, Ninola. Hey, Gwendolyn. Hälsa Live Podcast. Christina, Ghostery, Nana Misty, Happy Annie, and all the rest of you. And hello over at the Rumbles. And hello on Twitter/X. Yeah, for you who just joined, because, there's somebody live. Yes. If you watched Monday afternoon and Tuesday, then this is legal commentary and snark and name calling and bad words and yeah. If you don't believe me, ask my regulars. I can say, with my accent, I can claim that the F word is a fork. And if I should call someone and you see, did it just call somebody Farquad? It's the accent, I promise. It might come out different than I just said it, but it is always that thing. Yeah. Okay. Straight into rebuttal. We are going to speed through this somewhat because, as per usual, the prosecution is really boring. And yeah, let's go.
Okay, Mr. Murphy outside?
Your Honor, I'm going to get outside. I just wanted to put the court on notice before the jury came out that we are intending to tender through Mr. Murphy the
Why have you changed my
there? SW9, I believe, a proper interview. And as I stated to at least one member of the defense before we began lunch, we have
turn on the microphone, Ms. Love.
Prosecutor, at the beginning, there are various places throughout where he's speaking, and the portion in the beginning where he gives his name is the only portion that identifies him as who he is. The reason the state believes that it is important to play the portion prior to the start of the proffer is for the effect that those words would have had on Mr. Murphy, given his testimony on cross-examination. He was asked extensively about being in jail. He was asked about his trusting of his attorney and things like that, and what his attorney may have said or done. And at the very beginning of the proffer, Your Honor, we have the guidelines being set forth for the agreement, and essentially inside the proffer.
Mr. Murphy just got out of prison when he was arrested again for this charade. And faced with that, he took 4 grams of Molly, popped a few pills, and then he sat down. Yeah. And as is claimed during direct examination and cross-examination, he would have cut his arm off to get back to his family and his newborn son. So, let's see what is so damn important with her playing the beginning of that proffer. Hi, Fun Size, Auntie M, Maurice Rush, Eva Fenton, D. Robertson. Hey, you're gathering up a few. Good for you. Thank you so much for being here. Hit the thumbs up. You know you want to. I don't want to whine about it. You all know what? If you're here for more than 4 minutes, you like me enough to give me a thumbs up. All right?
Mr. Murphy is being told that they were getting ready to do a proffer. It's a final plea, that Mr. Murphy is in handcuffs, and that if he needed a break to speak with his attorney, he could. Also, he was explained that the proffer agreement it meant that he was going to speak to the state. There were promises that were being exchanged. The promise was that everything he told the state on that date would not be used against him, that the goal of the proffer is for Mr. Murphy to have been truthful, that he could not get into any more trouble by anything he said that day. Whatever evidence that the state had against Mr. Murphy had already been served. Whatever statements that he may have made in the past prior to that proffer were fair game still, and the state could use those against him if the case went forward. But on that day, which happened to have been the day that he entered a guilty plea, on that day, the state promised that it would not use anything that Mr. Murphy said against him, with 2 exceptions. In exchange for the promise, Mr. Murphy was asked to be completely honest, to be candid, to be truthful. Do not try to minimize your involvement. Don't try to minimize other people's involvement. Just tell us the truth, because the state is gauging how honest or how remorseful you are, and this is going to...
Yeah, this is just bolstering, in my opinion. I've seen too many trials where people will plea agreement, get up on the stand, and they say what they needed to say to get a plea deal. I don't like plea deals at all. If the evidence is there, charge them. If the evidence isn't there, don't. I think it's a bad plea. I think plea deals generally is a bad thing. Why? I've said it before. I will say it again. Prison snitches have everything to gain by lying and nothing to lose. Why? Well, if they lie and get caught, they still serve the same sentence. If they lie and be believed, they will get let out sooner or don't get charged at all. So tell me, folks, what does a prison snitch actually have to lose? Nothing.
Help the state determine if we can give him a negotiated offer for something less than what's already been offered right now. So the only 2 exceptions were that these statements to be used against you say that you decide to cooperate with us. He has not made that decision, and the state did not offer anything yet. But say in the future, Mr. Murphy did decide to cooperate with the state and took the stand, or he wanted to take a stand in his own defense. He had a right to testify on his own behalf or to not testify. But if he got on the stand and said something different than what he said in the proffer, the state would let the jurors know that one of these statements has to be a lie, and it was explained that that's called impeachment. So the prosecutor said that he would tell the jury that, I don't know which one's a lie, but he said 2 completely different things, and it's going to be up to you to gauge whether or not the witness is lying, and most likely he's lying to you if he said something different in court. So it was explained to Mr. Murphy that we can impeach his credibility with the words in the proffer, and it was explained that the other time that the state could use it against him would be in something called perjury. Say that Mr. Murphy had said something different when he's on the stand under oath, and he said something different than what he said to the prosecutor and to the investigators during the proffer agreement, and that is material. He was explained that materials means very important, something that makes or breaks the case. So he was told.
To my knowledge, none of the previous snitches have been charged with perjury, even though they try to get away and run away and answer completely, and yeah, none. Here's the thing. If they start to charge people who have received plea deals, why would the snitches keep snitching?
say if you say something inconsistent that is very important, not only would I impeach you and tell the jurors, hey, don't believe him. If that's important, I would also bring new charges against you for perjury. That's a completely new felony. That would be a new case. But this is the only time that I'm going to use this against you. If you lie, if you're just completely honest with me and tell the truth, you don't have to worry about anything. At that point, he was asked whether he understood everything that the state was saying. And then Mr. Murphy said, yeah, you said you want to help me, a lower plea, like an offer.
Shut up and play the video. You don't have to reiterate. You only need enough for the judge to say, okay, you can play that thing. You don't have to read it out every single sentence. But she does. Yeah.
And he asked, what are they offering now? The prosecutor told him that the offer at that moment is a non-negotiated offer that...
Yeah, I don't care. Let's see what Mr. Short has to say.
What is it that you're trying to ask me, other than the fact that
I just wanted to put that on the record.
Mr. Chowder Jimenez's involvement?
He's speaking. I don't want his name to be, we bleeped out his name. We completely took out his name. But we did want the admonitions that were given to Mr. Chowder, and I thought it was important that the court heard those. Those are the admonitions I was able to complete.
Yeah, but this will be interesting because I had it on in the background, but I didn't really pay that much attention. I'm not entirely sure that everything that was said are word for word as Ms. Love describes it.
Telling the court what they are. And Your Honor, so
You got the computer open.
yes. So Your Honor, given that we just wanted to make the court aware, concern throughout that portion.
Basically,
Either.
Your Honor, so basically, we had a hearing about this last week. We all discussed it. You ordered the state to do something. Instead, they did what they wanted to do. That's basically where we're at.
I'm going to omit the first 12 minutes. That's what I told you last week.
Your Honor, would we be allowed to ask him,
No,
was he
you
told
won't.
certain things?
I told you that last week. We could have had this discussion earlier. I'm going to admit it.
How about that? He's only going to admit those 12 minutes. This is a unicorn in this trial that the judge stands by his prior ruling. Maybe it's because he can actually remember the ruling from last week. I don't know. But without giving spoilers, this is a unicorn that he stands by a ruling.
I tell you, I told you last week. Look, we've been taking up 15 minutes in this. You said, and I told you last week, because Ms. Hilton said she's going to take out the 12 minutes. We're going to take them out.
Your Honor, given what was said on cross, and given that I did provide this to the defense, I sent them the copy with Mr. Chada's name redacted.
But you changed materially what I told you from last week. You're telling me something that you think is relevant at this point in time. I'm excluding it. That's it.
Your Honor, we're only asking that the court allow us to put it in
Shut
because
up.
it does.
And here, this she does all the time. She does not accept ruling. She keeps whining and bitching about it because it almost always works. She has gotten this judge to change his mind before, numerous times. That is why she doesn't accept his ruling. Even though, here's the thing, when a judge does this, you shut up, sit down, accept it. She doesn't, because she has no respect for the judge's ruling. And I understand why, because this judge doesn't have a spine. This is a unicorn if he actually holds on to his prior ruling.
Does impact how the jury should consider what Mr. Murphy's testimony is today when compared to what he told the detectives in that hearing. He was made promises, and on cross he was.
You more or less said word for word what he said. Word for word. You read the plea deal. It is up to the jury. Now you read it to them. Now they can decide for themselves. Was he lying? Was he embellishing the truth? Is the plea deal? They already have this. This is just Miss Love being an ass.
Asked about what he was promised. He was asked about the jail. He was asked about a lot of things on cross that at this point would make very relevant and very material the portion of the video that he is told the terms of his proffer agreement, Your Honor. That is the reason we are begging the court, because this whole endeavor is a search for the truth, that the jury be allowed to see what Mr. Murphy was aware of before he made the statements that he made because of what he said on cross-examination, which is different than what he said in the proffer. Had Mr. Murphy agreed to meet with us like he did
Mr. Sharp,
wait.
I believe that changes the equation though.
Ta-da. Ta-fucking-da. I said fork. YouTube monetization algorithm people. I said fork, as in spoon and fork. Fork. Nothing else. It's my accent. I know. It's my accent.
Between what you and Mr. Steele have asked already in terms of that.
Your Honor, it didn't change the equation. Respectfully, it didn't change the equation at all. The concern with the first 12 minutes with Mr. Chada Jimenez, the jurors have heard Mr. Chada Jimenez's voice.
But you opened the door as to it.
We didn't, respectfully, Your Honor, we didn't open the door. We cross-examined the witness. And quite frankly, I didn't open any doors. I opened windows and brought in light to this courthouse and actually took the time to allow the witness to review his statement and then was able to have a normal, competent state discussion with what happened. Now, Your Honor, I'll also point out, while we're talking about what the state didn't do, they also were ordered to take out the state comments by Mr. Hudson in the proffer, which are extremely prejudicial against the defendants, including Mr. Williams, and they didn't omit that either. So, we have to double and triple check to make sure the judge's order, Your Honor's orders are followed, and that's quite frankly not the best use of our time, and it's not fair to us.
Your Honor, that's not true. What Mr. Sharp asked for at letter L was that Mr. Chada, in this portion of the statement, if this portion is a statement, will have assumed a dual role in this case, serving as prosecutor and defense attorney. He was previously introduced to this jury. The contents can be elicited without revealing the identity of the assistant district attorney who was
But we
conducting
said
the
we would
proffer.
take out the first 12
No,
minutes.
I am. I'm just pointing out that what Mr. Sharp has said regarding not opening the door is insincere. He had just said something about if Mr. Murphy had testified consistently and Mr. Sharp had not elicited testimony, essentially that Mr. Murphy just wanted to get back and to his family and he would have cut off his arm, he would have done anything that he could.
He told that to you to Ms. Hilton on direct examination. You cannot. Here's the thing, folks. You can't open your own door. You cannot open your own door. He said it on direct examination. It doesn't mean that you get to open your own door. But here we are.
And if the statements that he gave to Mr. Steele were not inconsistent, and the statements that he gave to Mr. Sharp were not inconsistent with what he said in the proffer agreement, we would be in a different place. But the problem is that Mr. Murphy has agreed to speak with counsel for Mr. Steelwell and refused to speak with counsel for the state so that we can.
Hey, Christine, member for 8 months. Yay! Thank you so much for being a member for a whole 8 months, Christine. Thank you so much. Let's continue.
Even go over anything with him. So this notion that we were trying to hide it is false from Mr. Murphy. He refused to speak with us further until he got on the stand. He said, you can talk to me when I get on the stand. And so that's what we had to do. And the information that was given and elicited while he was on the stand makes necessary that first portion of this proffer where the terms of the proffer are laid out. And so at that point, it allows the jury to adequately and properly weigh the difference in the two statements and why there would be a difference in the two statements.
Who's giving the terms of the proffer?
That is Mr. Chada Jimenez. His voice is heard not just in the first 12 minutes, his voice is heard throughout the proffer. And there was never a
Still a problem. It's still a problem. It really is.
Your Honor, there was never
No, because here's the thing. You all chose to put this case together with Mr. Chada Jimenez in that particular tape. I think you got problems with it. You're gonna have to live with it. So I'm gonna exclude it.
If I may, Your
I'm
Honor.
gonna exclude it. That's my ruling.
Your Honor,
I've excluded it. That's my ruling. You've got some ethical and other issues bringing that. Even though you may have some issues with Mr. Murphy, I understand that, but this is not what you're going to be able to present in front of this jury.
Your Honor, the state had the privilege as it related to Mr. Chada and him.
Are you going to keep arguing with me or what? I ruled we're not going to cover the first 12 minutes. I told that to Ms. Hilton. She said she's going to agree to that. Yeah, you can still ask him questions. You got a written, do you have a transcript of the proffer?
Yes,
Then use that.
that was what I was asking.
Use
Thank
that.
you. We'll
I don't
go
have any issue with that. I told you that.
Okay, we'll go past that. Thank you. And Your Honor, as it relates to Mr. Sharp's comments to the court about what Mr.
Judge Glanville just undermined himself. You fucked right. I said Farquad. I promise it's the accent. It's the accent. YouTube's thing is. I said Farquad. Yeah, and she can't even take this win. She has to keep being a female dog.
Hudson said, actually, Judge, that was as it related to the August interview. There was never anything in this motion.
You're not making Mr.
Hudson.
Hudson's statements. I think we're supposed to exclude those as well.
No, you only said to exclude the ones in the August statement where they left the room, and only Mr. Hudson and Mr. Murphy
Yes.
were in there.
Yes. Okay.
So, no. there
All
was-
right.
So what you-
Yes, sir.
Your Honor, I asked for any non-testifying person. That was what I asked you in my motion, not to be allowed to get in via recording. They're not testifying. Attorney Hudson is not testifying. The state has it in this exhibit, I don't know the number, from 46 to 4630, and I'm strenuously objecting. In addition to that,
Who's that? 46. What part of the?
Mr. Hudson is the attorney for Mr. Murphy. He's in the proffer.
What-
There's Detective Gaither, Detective Dennis, prosecutor at that time, Jimenez,
Mhm.
Mr. Murphy in handcuffs. Those are the people I believe are there. Mr. Hudson says we are not, he gives multiple statements, but we are not discussing Jeffrey Young Thug Williams. I can't cross-examine him on why he would say it.
Yeah.
So I want that out respectfully. And you granted it.
That needs to be excluded. What else?
We can take that out, Your Honor, but this is the recording that has already been admitted as evidence has that in there.
What?
It has that portion.
Hold on. You mean the proffer?
But we can mute that part. We'll mute that part. 46, 02 to 4622, we can mute that part.
In addition, Your Honor, at 2750 through 29, Detective Gaither is telling Mr. Murphy, Fatty is not in the car. Mr. Murphy is the only one who identifies Fatty as being in the car. And that's not what her.
Detective
Gaither.
Gaither is testifying, though, isn't he?
And not only that,
It's a
Your Honor,
woman, but I believe
She's testifying, isn't
She is.
So she can cross on that.
and not only that, Judge, but Detective Gaither, she is pushing against Mr. Murphy and telling him that she knows Fatty is not in the car. Mr. Murphy consistently says that it's Fatty in the car. So there's nothing about that portion that should be a problem. He maintains that even when she pushes back against him.
And
And
that's
that's the kind of thing.
Yeah. If you wonder what happened here, now prosecution is slowly sliding in different things they think they can get away with. Luckily, they have the defense have Mr. Short and Mr. Steele. Problem is, on that bench up there is a fuckwat. I said fuckwat. I promise. It's the accent. When I say it out loud, it just sounds differently.
Well, the Detective Gaither's statement, I'm not going to exclude that. That's a weight versus efficiency. She's going to testify. So I'll disallow that. I mean, in terms of it doesn't need to be cut out. What else, sir?
Your Honor, in addition, I am moving to exclude the entirety of the recording for two reasons. One, under 24-6-613. And Your Honor, that's in Division B, as in Barry Bravo, C as in Colette Charlie. So you're going to have both. I don't believe that this meets the mark of a prior inconsistent statement. That's in B, Your Honor, or a prior consistent statement, because I, nor Attorney Sharp, nor anyone to my hearing has raised any allegation of recent fabrication, improper motive, or improper influence with Mr. Murphy, which is the only way to do a prior consistent statement. Mr. Murphy is almost entirely consistent with his testimony. If this honorable court says pieces are inconsistent, which I'm not agreeing, but if this honorable court finds that way, then the state didn't lay the proper foundation. He kept saying, I don't remember. Now, I don't remember is a way of saying, I deny it. I mean, case law says I don't remember is equivalent to that's not accurate or that's not true. Or I didn't say it. But what he is saying is I don't remember because this is not a statement that was within a year. This is 8 years ago. This was a 2015/16 statement. And the state never pointed him to it, showed it to him and said, isn't this your voice? Isn't this what you said? And then on cross with Attorney Sharp, I didn't do it. Attorney Sharp went through almost every bit of that interview and he agreed with every bit. So I don't believe that it's a prior inconsistent or consistent statement. So I don't understand, unless the state has a specific, piece, I don't understand how we're listening to it again.
Your Honor, if I may, we did not listen to it the first time, and Mr. Sharp entered it as evidence under no objection from the state. So it is already that those words are already in evidence. Number one, there was no objection when they tendered it. There was no objection. Mr. Steele could have objected. He could have said, no, it's not a prior inconsistent statement. It's not a prior consistent statement. He did not. And in fact, what words are on that CD are in fact inconsistent with what the witness testified regarding on direct. And the reason, and first of all, I'm certain that Mr. Steele is not asserting that.
Here's the thing, Ms. Love. You deliberately took it out just to ask him about stuff 8-9 years ago when he was high as a kite. You were searching for inconsistent statements. You did. Then on cross, okay, there they are. So this is the shadiness of this prosecution. This is how they plan it out. So Mr. Murphy is on the stand trying to remember something 8-9 years ago when he was high as a kite. This is pre-planned. They are opening their own door by claiming this is an inconsistent statement. Well, why didn't you refresh his recollection with the video? Well,
we have to refresh his memory before we confront, and that's the way that we have to confront him. We painstakingly confronted him with statements that he made in 3 interviews, and he made inconsistent statements on direct. He chose to not speak with the state. He said we can speak with him when he gets on the stand. He chose to speak.
how did you refresh his recollection? By asking him questions? No, this is the state opening their own doors. It's so shady. It's unethical. If the judge had a spine, he should have thrown this out ages ago, but he won't, because he has no spine. And the prosecution is as ethical as District Attorney Fannie Willis. The liar in the house of, she lied in the house of God, fornicator of a married man, and helped that married man to forge statements in his divorce proceeding. That is the foundation this assistant district attorney is resting on. Lying liar who lies.
With Mr. Stillwell's lawyer, and so.
All right, Mr. Steele, I've considered your objections. I'm gonna overrule them at this point in time. You may have a continuing objection, yes, sir.
As you recall, Your Honor, I admitted the proffer, subject to your rulings and for the purposes of the record. As we've been doing with all sorts of things, that doesn't mean it gets published to the jury.
What do you want to tell us? What do you want to tell me?
Well, it doesn't mean I didn't publish any of it to the jury, and so I was admitting.
No, it's been admitted, subject to some objections and
subject to objections
and some rulings that I've made, such as I've chopped out the first 12 minutes and the other things that are objectionable.
And subject to the rules of evidence. And Your Honor, I'm not trying to relitigate. If you're finding the prior inconsistent statement sets your ruling, I'm not trying to argue that. But just because I admit something for the record doesn't mean it automatically gets published.
I understand that. But
okay, all right.
That's a totally separate issue. I mean,
okay.
It's based upon what Mr. Murphy's testified to on direct.
Okay, I just wanted the record clear on that matter. Thank you.
All right. Let's bring Mr. Murphy, please.
For you who wonder, we are doing recap Monday afternoon. Tuesday is just 90 minutes yesterday. And today's trial, Wednesday, starts at 1:30 p.m. if the judge...
All right, starting some jury,
we have plenty of time for me to do my legal commentary, snark, name calling, whatevers. And for you who don't know, hi, I'm Nick. I do labor law. I've been doing it for over 30 years. I am trained in evidence evaluation. I'm trained in evaluation of witnesses. I have training. That's what I want to say. Yeah. So I've never done criminal law. I will say that out loud. I've never done criminal law. I have supported things within labor law that went to criminal court, but I did not do the criminal aspect of it. So we learn together, because some of this is new to me, but I've been covering this case since May of last year. So I know more about Georgia RICO than I want to know. That's life. You live, you learn, you drink, you throw up, you go to bed, and then you wake up the next day. Dun, dun, dun. Jury is here. And Miss...
Yeah, Mr. Murphy. During good afternoon.
Good afternoon.
During cross-examination, do you recall Mr. Matthews, this gentleman right here, asked you a few questions?
Yes.
Okay. And do you remember him asking you whether or not we as a state showed you any videos or played your statement prior to you taking stand? Do you remember that?
Yes.
All right. How many times have you and I met
Right.
before coming to court?
Twice.
When were those 2 times?
At court and when y'all came to my house.
And do you remember when we came to your house?
I don't remember the date, but it was probably a couple months ago.
Was it this year, 2024?
I ain't sure.
Okay. Did I come by myself?
No.
Do you remember me being with an investigator?
Yes.
How would you describe our interaction when I came to your home?
You mean like one word or like describe like what happened?
Describe first in one word and then what happened.
It was a meeting, like a peaceful meeting.
It was peaceful?
Yeah.
Were you cordial to me and I was cordial to you?
Yeah, we was respectful.
Okay. And what did we talk about at that meeting?
Me being subpoenaed, a couple subject topic.
Did we talk about your kids?
Yes.
Did I ask you if you was gonna marry your girlfriend?
Yes.
Did we talk about other things outside of criminal activity?
Yes.
And during that meeting, did I ask if you and I could meet again?
Yes.
And initially, did we set up a time for me to come back the following week to meet with each other?
Yes.
And did you initially agree to meet with us?
Yes.
At the conclusion of that meeting, did I begin asking you about Shay?
What the conclusion, like the end.
Like towards the end.
Yeah.
And how did you feel when I asked you about Shay?
I felt disrespected
And why?
because I felt like that was my friend. Like you in my dining room while eating dinner with my kids that asked me did I rob my friend.
Okay. And after that, though, did you still agree to meet?
Holy fork. In front of his kids? In front of his damn kids? In the Miss Hilton, that's so low. That is so low. I need to have what you bunt, but I exchanged the C for a B.
Yes.
All right. Did my investigator make contact with you? And let me back up. You said you felt disrespected. Was I disrespectful when I asked you, or just the fact that I asked you, you felt?
I'm overruled the objection.
Did you think that I disrespected you, or the fact that I asked you about her was disrespectful?
Yes. The last one.
Okay. Once we left, did my investigator try to make contact with you so that we could meet again?
Yes.
Did we meet again?
No.
Why not?
I told him I didn't want to. So I talked to my lawyer after that, and he told me if I didn't want to meet with nobody, I don't have to. As long as I agreed to come and testify, and that's what I had to do.
Okay. And so did you decide not to meet with us again?
Yes.
And did we ever contact you and ask for us to meet again?
Huh?
Did we ever call you and ask you any more to meet with us?
You mean like after I said I didn't want to meet? No.
And when was the next time you heard from anybody in my office?
I think a couple days before I had to come here or something, a day before.
And the Wall of Doom. Hey, Nana Mystic gifted 5 memberships. Thank you so much. It went to Sweet Pea 777, LaShawn, Caroline, Wawa, and Gwendolyn SS. You who got it, give your thanks to Nana Misty. And you who got it, you now have access to all my members-only content. And I just released a short earlier today, I think. And I had a members-only stream on Friday. And I have somewhere between 50 and 100 hours of content for members only on my channel. So we get to know each other better. You know a bit more about me, my farm, the renovations, my tractor, and stuff like that. Let's see if the World of Doom can just go away.
Oh, 2 days before, something like that.
2 days before you had to come testify?
Yeah, it's in that range.
So is it safe to say that I couldn't show you any videos because we never met?
Objection, Your Honor, leading.
I stand questions.
Was I able to show you any videos?
Was you?
Objection, speculation.
I stand as to form.
Did I show you any videos the first time we met?
No.
And was it initially we were going to meet again? Initially before you said no?
Yes.
All right.
Here's the thing, folks. He contacted his lawyer, who said you don't have to meet with them if you don't want to. It's not in the plea agreement. Here's what the prosecution could have done. They could have subpoenaed him for a meeting. Yeah, the prosecution can actually do that. They chose not to. Instead, they planned this.
Now, I want to show you what's already been admitted as State's Exhibit 23, Alpha Alpha. Who's that is 23 Alpha Alpha?
I don't know who in the phone or who in the picture.
Who's in the picture in the phone?
Me and Lil Jeff.
And do you remember when you took that picture?
No,
Okay. Is that what you looked like in 2013?
I don't know what. I look like that a lot of years. I look like that now, though.
You said you don't look like that now?
I look like that now, though.
How is this evidence? It's a picture of a picture in a phone. How could this be admitted?
My hair just.
Did you know if that was a picture that that Shay gave to police in May of 2013?
How would I know that? I didn't even know nothing about that.
Somebody else gave the cops that picture, and she asks him about it. This is weird.
Okay. Thank you. Now, on cross-examination, Mr. Sharp asked whether or not the two of you spoke, I think last week, and you said we nodded at each other. You remember?
Thank you, Valpal. Gosh darn it, stop doing the wall of doom. What's going on here? Why does it go through the wall of doom? Removing that. I have a few apps that sometimes just eat up my memory here. Let me see if I can turn a few of them off. I need the enhancer for YouTube because otherwise the sound is more horrible. Yeah, let's try it.
Telling Mr. Sharp that?
No, I said I nodded.
You nodded.
I nodded at everybody.
Had you met Mr. Sharp or anyone else prior to coming to court last week?
When you say prior, you mean like?
Before you ever had to come to this courthouse, had you met Mr. Sharp or any of the other defense attorneys prior to you having to come to court last week?
Yes.
Who have you met with?
Mr. Steele.
Is that it?
I seen Mr. Shaw at his office, but we didn't how you say converse. We didn't converse.
Okay, so Mr. Sharp was at Mr. Steele's office, but you and Mr. Sharp did not speak with each other.
He walked past.
How many times have you met with Mr. Steele prior to coming to court?
I want to say like 3 times. One time, he came to speak to me while I was arrested. While I was locked up on this case. And then I went to his office one time, and then Zoom one time.
When you met with him at the jail, about how long did y'all speak with each other?
I can't remember. That was a minute ago.
What about when you went to his office? Do you remember how long y'all met with each other?
Probably about 30 to 45 minutes. I had to go to work, so I was kind of rushing.
And then what about the Zoom meeting?
Listen, Till, what's the relevance of this? I have no idea other than presenting to the jury, this is a shady guy. The defense is shady. They are meeting with the witnesses. Here's the thing. The defense can meet with the witnesses. They can conduct their own investigations. They can conduct their own interviews. They can. So this is just, I don't know why they don't object. Maybe it's a standing objection, or depending on what she's trying to get through. I don't know. Listen to it. It sounds like she's trying to imply there's something improper in talking to the defense. Yeah, I agree. That is what it sounds like.
Probably about the same, about 45 minutes.
When you met with Mr. Steele, was that before I came to the office?
Probably right before that. I can't really remember, but they aligned. So it was...
Now, since you've been on the stand, you've allowed Mr. Kokomo, Mr. Kokomo let you listen to the audio of your phone. Remember that?
Yes, we was outside, yes.
Now, since this break, did you meet with Ms. Knight, and did she show you the video of that same property Mr. Kokomo showed? Yes,
that was the same. That was the same thing, though?
Did it sound like the same thing?
I can't. That was days ago he told me that. I've been home with my kids. I can't remember.
Let me ask you this. With what Ms. Knight showed you, do you remember that being a property you took in February 2006?
Yes.
And did that appear to be a fair and accurate depiction of the proffer that you took in February 2016?
Yes.
And have you had opportunity to review it and sign and date that proffer that you took in February 2016?
Yes, we scanned through it and I signed it.
Okay. And it appeared to have everything that you talked about that you don't call it this.
Yes.
Commissioner Cochran?
You may.
I'm showing what's already given to the defense counsel, but what's going to be marked as 33 Charlie. Do you recognize that CD?
I just signed it. No problem.
And did you date it?
Yes.
And that was at the video that Ms. Knight showed?
Yes.
You're right, this time say like 10, 16, 33 Charlie with what we discussed in that.
Any further objection or continuing objection? All right, so noted. It's admitted, subject to the court's prior ruling and the continuing objection.
And permission for it to be published.
May be published.
Now, Mr. Murphy, during that agreement, did the attorney speak with you about what a proffer agreement was?
I can't remember. I just remember we had that little meeting.
Let me ask you, did the attorney tell you that he want to record that? You remember?
I don't know. I would have to like look at it to see. I don't remember.
Let me ask you this. Did he go over the proffer agreement, like why you were there? Did he tell you why you were there?
A sustained objection. You rephrase.
Why were you present inside this room?
It was
Why can't you talk into the microphone, Miss Hilton?
Sure, I'm sorry. Why were you present in the room?
that was good timing.
we was having a like I call it a meeting. Y'all call it something. What do you call?
A proffer?
Yeah, that.
And was the expectation of that proffer for you to be completely honest and truthful?
I'll sustain that as a form of question. Why don't you just read? You got my redirect. So
Were you in handcuffs during?
I can't remember. I can't see all that. We just looked at it for a second. She made sure I recognized that was me and my attorney, and I signed it.
Permission to publish it, Your Honor, the portion.
yes, ma'am.
And now I guess, yeah. Now they're going into something that is extremely boring. Yeah. The defense did not even show him the full video. The defense showed him bits and pieces that they were going to ask about. Now, except for 12 minutes and then beeping out. Here's the thing with beeping out. When you hear something bleep, don't you assume it's a bad thing? That is why you redact it completely, not just bleep it out. It's for a few years ago, it was very popular meme to add a filter to people who did something mundane, but with the filter on it, it kind of looked like they were doing something very, very naughty. That's about what bleeping out in court, because you get the notion, oh, this is bad. It was so bad, they had to bleep it out. Hi, Shanagram. Good to see you. Yeah, Valpal, do not sign things without full review. What you also invoke your Sixth Amendment rights. Shut the F up. That's not even legal advice. This is something you already should know, but I'm just reminding you of it. Here's the thing. Prosecutors always want to make it easier for them to prosecute. Many judges also, it should be easier to prosecute and convict. No. It should be really, really hard to convict. Hence, the presumption of innocence. You are innocent until a jury of your peers says otherwise. And then all the due process and everything, yada, yada, yada. Instead, it should be, because they have to prove things in court beyond a reasonable doubt. What is reasonable doubt? Well, that's different between depending on who you are and what you think is reasonable. Me, personally, when I watch a trial, I listen to the opening statements, then I have a number of questions. During the prosecution's case in chief, they should answer every one of these questions until I only have unreasonable questions left. If they fail, well, you better hope that the defense forks things up, because otherwise it's not beyond reasonable doubt. Not for me, at least, but that is how I function. And I am very pro-defense, usually. And I do have training, so which means my, what do you call it? My line of reasonable doubt might be higher than the normal person. But that is how I do. These are all my questions. Prosecution better answer all of them. In some cases I've been covering, I got more questions in the end of the prosecution's case in chief. And we have a visitor. Hello, Mr. Jingles. Hello. Oh, he's so happy when I show him to the world. Hello, Mr. Jingles. Is that you on the screen? Hello. Oh, ow. Yeah. Ow. Yeah, that's my asshole cat. Okay. Enough ranting here. Let's get back to the trial. Oh. Skip ahead.
2015.
Yeah.
Then we speak now.
Here's the thing. Let's play a few minutes of this.
April 12, 2015.
Really
2110 Brownsville Road.
nothing
Direct safety.
unexpected.
Okay. Whose vehicle?
And then I
2015, 2110 Brownsville Road, direct AP case number 15102-2458. Incident time is between 21:30 hours and 21:48 hours. Mr. Murphy, if you would, tell me what you were doing just before this incident occurred and where you were.
I was at the spot, at the spot on Hot Rock spot.
Hot Rock spot.
I forgot the name of the street, but off Roman
Okay, when you say spot, what do you mean?
house.
Just a regular house? Is that where he lives? Or lived?
A house where everybody hung out at.
Okay.
We were just chilling.
Okay, who all was there with you?
Me, Fatty, and no, I was in the back.
Anybody else?
Can't really, I think it was like a Jay working the door or something.
When you say working the door, what do you mean? You said working the door.
Yeah, answering the door.
Oh, is it like a dope house? Did they sell dope out the house? Like I'm just trying to. You said working the door. Like why do you think somebody? Okay.
I can see from this grainy video, this man is stoned out of his mind. And it is my Valpal, it's my understanding that the case attorneys here is good friends with Fanny. I would assume so, because this, I believe, is right. Because Fanny Willis, if you don't know, was YSL Mondo's defense attorney. So she was a part of the public defender's office. And I've said this before, if you're completely new here, here's my theory. Every bit of foundational in this case, Fanny Willis got through attorney-client privileged information. And that is why YSL Mondo is not charged in this trial. But YSL Mondo is on the defense witness list. And I hope to all that is holy that he spills the beans on Fanny Willis.
So you, Fatty, and Nard, and maybe a Jay that was at the house.
Yeah.
Okay. What happened next?
We were just chilling, huh? And I came out back. And he was like, "That right, y'all, that right." And I was like, "All right." So when I got up, he walked back in the kitchen. And when I got up, he handed me a chopper.
So Nard handed you a chopper?
Mhm.
Who all left?
Me, him, and Fatty.
Okay. Whose vehicle were you all in?
Bentley,
And what type of vehicle was that?
the white Jeep truck, the white truck.
White truck. This part here is important. What exactly did Nard say when he came out the back? And I assume you and Fatty were in the front of the house. When he came out that back room, what exactly, as best as you can remember, were his words?
I think the best I can remember was I think he said, "Let ride, let ride."
What did you take that to mean?
Like something going down, we gotta ride.
Okay. Something bad going down?
Yeah, like something going down.
Okay.
If you remember my stream Monday, when I saw the video from that gas station, My impression is that whoever was in that dark car were acting as an active threat, in my opinion. So I know what comes later on in this recap, and it's very unfortunate what happened to him. I don't think that person was an innocent bystander for a second. FOFA, fork around, FAFO, fork around, find out. And if you are involved with criminal activity, the finding out part can be a headache, so to speak.
Why did you take the assault rifle from him?
Why did I take the assault rifle from him? To be honest, like I thought it was going to go down like right there. I thought somebody would come to the spot. Because we had so much going on, like defense. So I thought somebody would pull up on the spot.
Okay.
But then we jumped in the truck. I knew we were going to either do something or something had went down and we had to pull up on the scene.
Okay. Did he say?
I agree with Pat B here. They shouldn't question suspects if they are high. And this has been told by the defense and without objection from the prosecution. He told the people in there that he just popped a bunch of pills and 4 grams of Molly before going into that interview. How it is not thrown out? Well, it's because Judge Glanville has no spine. He wants a conviction as much as the prosecution does, and in my opinion, he is more or less a part of the prosecution's team.
Why you guys had to ride, or who called him?
Not at that moment.
Not at that moment. When did you find out?
When I got to the scene.
When you got to the scene? Okay. And what was the scene?
Store.
The gas station? Okay. So when you got to the gas station, continue from that point.
We pulled up to the gas station. I think, if I'm not mistaken, I got out first, or me and him got out at the same time.
Mm-hmm.
And we walked to the front of the store. When we walked to the front of the store, we opened the door.
Mm-hmm.
And when we pulled up, I seen the car Bentley was driving earlier, which was Hot Rock car.
The car that they were,
like something.
the car that Bentley that was in.
Yeah,
Okay.
sedan, black. Bentley was driving earlier, so I seen it and I knew it was like, you know what I'm saying? So when we opened the door, I seen Bentley and I'm like, come out, come out. I'm holding the door, like in the middle of the door. Come out. And they were acting scared, like.
When you say they, who are you talking about? Who did you see at the store?
I seen Bentley, I seen Hot Rod, like standing in the back, like Thomas on the phone or something.
And who else did you see?
Bentley, Hot Rod, in that point.
Okay.
And then they told Nard something. And then I came out, he pointed at the car.
Pointed at which car?
And,
Yeah, this is boring. We know basically already what's going on here. And in my opinion, the state tried to open their own door and the judge allows it, more or less. So this is basically the 3rd time the jury hears what happened in this proffer, which should be the prosecution stacking. And that shouldn't be allowed. But in Judge Glanville's court, it is. So, yeah. Let's see if they... Then they have a break. Then, oh, there. There. Yeah, I got bored.
Glanville, just want to introduce myself. Look, I understand that you were supposed to be called today. We're not in a position to get to you quite yet. I just want to tell you it's nobody's fault, but just the process. But can I ask your assistance in coming back tomorrow for, if you could be here for 10, we'll start somewhere between 10, 10:30, hopefully. Is that all right? And we apologize, but we just we're running out of road today. And I don't want you to stay here much longer because I doubt we'll get to you by the end of the business day. Okay. All right. So we'll see you tomorrow morning for 10:00. 10. Yes, ma'am. All right. We'll see you then. Okay.
Yeah.
So I'll release you this one time.
That is one of Tuesday's witnesses that was told, yeah, you can go home because, well, I assume that Judge Glanville will, hold on, there, this guy will blame the defense. Again, he does that. even though it's still the prosecution's case in chief. This should have been a 6-month trial. That throughout the pre-trial, which I covered, 6 months. What's what the judge said. We are 4.5 months in. A little more than 4.5 months in. The state has called 44 witnesses out of 209. 44. 4.5 months. According to the original timeline, the defense case in chief should have started right about now. And the prosecution they aren't even halfway. Barely a third.
We'll see you in the morning.
Keep ahead.
Audio recording with Mr. Suri going over the proffer agreement. What we've done to try to expedite that portion of it is we actually have a copy of the proffer agreement that Mr. Murphy signed back in 2016. We have provided the defense a redacted version that redacts Mr. Chada Jimenez's name from the front page of the document, as well as the back portion where Mr.
They waited until now to do it. The judge ruled on it last week, and they just got to it.
Jimenez signs the document. And so I don't intend to admit the plea agreement. Excuse me.
In the plea agreement, one Charlie or whatever.
No, Your Honor, that's the proffer from this case, Your Honor.
All right.
So the state at this juncture, because I don't believe we have a redacted version of the guilty.
Oh, I'm sorry, you do.
Okay, so we do have both. So we'll tender both the redacted version of the proffer agreement as well as the redacted version of the guilty plea and plea agreement, Your Honor.
All right.
In this case, which was 15 SC 138234.
All right. And
Charlie.
It's redacted, but it's written by Mr. February. Your Honor, 33 Charlie Colette Alpha is a February 2016 letter, and it is written, it's redacted, but it's written by Mr. Jimenez, but it is redacted. His name is not on here. And it's to Jacoby Hudson, who's not a witness. And it talks about that in Con 1, the Office of Fulton County District Attorney, the state, quote unquote, requires completely truthful statements of your client. At the bottom, on paragraph 6, the proffer is to be provided for the purpose of allowing the state to assess the credibility and value of this evidence and possible testimony we believe your client can provide. Number 7, no promises, agreements, or conditions have been entered into other than those set forth in this agreement. None will be entered into. All of this is hearsay and confrontation clause. This is built for a confrontation clause, and we can't cross-examine either Mr. Hudson, who received it, or Attorney, then Prosecutor Jimenez. So I'm objecting to it, and I don't see the relevance of it. It's to bolster the district attorney wants truthful information before a jury. That's bolstering. Self-serving.
Let me ask you a question. Does the plea agreement have these same terms in it?
It does not, Your Honor. And the reason why it's not bolstering is because Mr. Murphy has consistently said, both in direct and in cross, that the reason why he would cut off his right arm and just say anything in order to get out of custody. But this agreement, he went over, it's not hearsay because he went over, this was gone over with him. This is the part that was cut out. Every portion of this was gone over with him. And then he himself read it and signed it and agreed to these conditions prior to giving the proffer. And so when he comes in court today and says, I would have said anything, well, that's not the guise in which he was following at the time in which he gave the proffer.
Ta fucking da. Ta-da, ta-da. Here's the thing with plea deals. The criminals accept it and then they move on. They don't expect to be in this charade that is called a RICO case. Because it is a charade. Georgia RICO Act is so broad and so vague that it allows the furtherance of the criminal enterprise to be spoken and unspoken. Can you be more vague when the prosecution only has to show that they agreed to this without saying a word? Without writing it down, without a recording of it? They just have to say, well, they agreed because they might have nodded. It's a circus, it's a charade, it's a waste of time and money. I've said this before, I will say it again. Every trial day, between 4 and 8 other cases could have been held in this court. Misdemeanors, minor crimes, up to maybe even a few felonies. On average, 4 to 8 cases. If this trial lasts 200 days, it will. That is between 800 and 1,600 cases that will not be heard in this courtroom. That is between 800 and 1,600 victims who will not get their day in court. That are cases that will reach the statute of limitation because this trial is ongoing. How is that justice?
If he signed the document, Mr. Steele, the fact that Mr. Hudson, you're not going to examine him anyways, is all being offered for impeachment. So,
Well, okay, I'm just voicing my objection that it should not come in respectfully. It's self-serving to a party opponent. That's the district attorney's office specifically says they want complete and truthful statements. That should not come into the evidence. And number two, it has no relevance to this matter. The gentleman can be asked, did you lie? Did you tell the truth? And what was the ground rules were this? You don't need a document. And I'd be objecting. I know you always tell us you'll decide that later about the continuing witness rule, but clearly it would be. Anyway, hearsay confrontation clause. On 33C as in collect, B as in Barry, Charlie, Bravo, Your Honor, this is before the Honorable Judge Esmond Adams, and this is the plea agreement. And in paragraph 3G as well as I, it discusses appellate rights. And I've already objected to anything about appeals in this case, and it should not come out. In addition to that, in paragraph 8, it says the same thing as what I've objected to in 33C, Colette A, Elisa, or Charlie Alpha.
Mr. Steele, I really would like you to use the military alphabet.
You got to.
I'm going to. Yes. No. We're going to. No. Your bride is a very nice lady, but I would like you to use the military alphabet. Okay. No, I don't need duplication. Just makes it simpler for us to kind of go through. All right. So please.
In paragraph 8, though.
Okay.
It says on the first 2 lines, following the defendant, who would be Mr. Murphy, agrees to cooperate truthfully and completely with the state, including being debriefed and providing truthful testimony at any proceeding. So why do we need twice? Why do we need a letter from an unwritten person, because the prosecutor's name is erased, to a lawyer who's not testifying, when the first 2 lines, if you let it in, says the exact same thing?
But it doesn't have anything to do with the lawyers. It has something to do with Mr. Murphy and his testimony. And since he's being offered for impeachment, if he's confronted as to it, or testifying inconsistently to what he's already testified to.
I don't see it being inconsistent, but
The statements, I mean, in terms of being, I mean, were you honest? I mean, did you attempt to tell the truth when you signed this agreement? I mean, I think that it's relevant to show that.
But in one of the first document written to the Honorable Attorney Hudson, it reads, and I'm just quoting, it's in the first line and first word of number 1, paragraph 1, it's number 1. It's paragraph truly numbered 1. The officers of Fulton County District, and then it says state, requires completely truthful statements of your client. Why would that go in when 8 says on the other document, the one to the Honorable Judge Esmond Adams, the defendant agrees to cooperate truthfully and completely with the state? And why do we need that the state mandates truth versus the defendant agrees to cooperate? I don't know if I'm articulating well, but my point is it's bolstering the prosecution, the district attorney's office. That's my objection.
Okay.
And then paragraph 10, it says the same thing.
In what document, sir?
The second one, the one to Judge Esmond Adams.
What number is that, sir? For the record, just so I can
33 CB.
30C Charlie Bravo. Okay, all right.
Yes.
Okay.
This one, the 4 lines up in paragraph 10. It's on page 3 of the document, Your Honor. It says, if, however, the state determines that the defendant has not been completely truthful and candid with his cooperation with the state, he may be subject to prosecution for perjury, false statements, obstruction of justice, and any other appropriate charge, and all information he has provided may be used against him in such prosecution. So my point is, if you let it in over my objection, I'm not waiving any objection, but it's all consumed in 33 CB is my point, without the language that the state requires completely truthful statements.
All right. I'll hear from the state.
Okay, thank you.
Sir, thank you. Yes, ma'am.
You're right. Again, the state is offering both 33 Charlie Alpha and 33 Charlie Bravo for its effect on the listener. Again, Mr. Murphy through.
For its effect on the listener. Yeah, that's a stupid rule, but it's in effect. But here's the thing. They have gone through all of this twice on direct, once on cross, and another time on rebuttal here. Why do you need, again, that is bolstering, but not in this court, I assume.
Out his direct and his cross said, I wouldn't have said anything just to get out of that room. What 33 Charlie Alpha specifically, as it relates to what we just saw, is in the beginning of this proffer that we just watched, that these 12 minutes, the prosecutor went over the entire document. He then signed it and continued with his proffer. This is the portion that.
Yeah. And so it goes on, and they will play it, and he will read it, sadly. So let's skip ahead to after the judge sent home the jury for the final
State, do you
minute.
have your witnesses ready for tomorrow? I know we have many witnesses who'll be here at 10, so that should be perfect.
Then
Anybody
we
else
want to
that we're going to call or appear from tomorrow?
Yes, Your Honor, we anticipate hearing from two more, potentially Dexter, Montgomery, and Dexter.
Okay, all right. Well, just judge your time accordingly. Okay, all right. Anything else I need to take up before tomorrow, counsels? Mr. Steele?
Can I ask a question?
Yes, what's your question, sir?
Thank you, Your Honor. If the state could tell us, is Detective Gaither and Detective Dennis, are they multiple witnesses? Because I didn't want to cross-examine them, other issues too, but investigator Belknap or Detective Belknap, I just want to do it one time. Can I just inquire if that's okay, whether this is going to be a multiple, jump around witnesses to be recalled, or if it's one time, if you don't mind, inquiring in the state town?
Not jump around, but multiple, because they're different. They're being testified to,
So, okay, let's just break it down into how many times you anticipate your first witness to be testifying.
Yeah, how about that? They have roughly 160 more witnesses to go. They also want to recall a dozen of them for different aspects of these underlying acts and overt acts in the RICO charge. So it's like having, instead of 160, they have 180 more witnesses because they are going to recall some of them. It's so infuriating. The absolute waste of time and money. If this is a year-long trial, my rough estimate is that this trial will cost Fulton County taxpayers at least $10 million. That could have been used to solve current crimes. Instead, they are going to yap around with things that are 10 years old.
So the first one will be Rose, and she's just that. And of course, the late witness just 2 months.
Speaking to microphone, please.
I don't anticipate-
Microphone. So everybody can hear you.
I don't anticipate calling either of them more than twice.
Who is that? Who are you
Gaither
talking
and
about?
Dennis.
Okay, so Gaither and Dennis will be called twice, you think?
Hold on, Your Honor, just 1 second.
Miss Love does not know where the camera is. They're very
So
lucky
Gaither no more than
the
twice.
camera is wide
And
angle.
Dennis, Your Honor, let me look at my order. For the purpose of tomorrow, Gaither no more than twice. And I will let the court and Mr. Steele know, and I can speak to them offline with respect to Dennis. I believe that we, in our previous orders, approved given to them as to which person would testify about what act we have asked that we anticipate him testifying to.
So is he only going to be called once, or are you going to let me know tomorrow?
No, we will let you know tomorrow, Your Honor. We have already let counsel for defendants know acts that we anticipate them testifying to. That's the only reason I said it's offline.
Okay, listen, I think Mr. Steele just wants to know whether or not you're going to call, how many times you're going to call each respective witness. So, so he can make a decision as to whether or not he wants to examine them all at one time or accordingly. Okay.
Yes, Your Honor.
All right. Anybody else? Anybody else?
Investigator Gaither tomorrow is subject to the testimony limited to Dexter Montgomery. Is this overt act or is there more?
It would definitely be as to the Dexter Montgomery act. We won't cover another act tomorrow.
So it's just the Dexter Montgomery Act, correct?
So just as to the,
All right. That was the last of Monday. Now, Tuesday. Let's see here. Dun, dun, dun. Dun, dun, dun. Dun, dun, dun. All right. Tuesday. Yesterday. This is a grand total of 90 minutes tops of testimony and actual trial, playing it in 1.5 speed, and I might skip over a few things. So Daily Quick Bites says Solving current ordinary crimes does not advance careers and win elections. This case isn't about justice as it is those foregoing objectives. Here's the thing, and before Fannie Willis was discovered as a liar and a fornicator of a married man, she was going for the Attorney General's position. Now she aims to be re-elected as a district attorney. I'm not a political person, but I do like competence. You could vote in a hobo from under a bridge who runs for district attorney, and that one will do a better job. Anything but Fannie Willis. Let's move on with Tuesdays. Skipping ahead. The World of Doom, of course.
Morning.
Roll call, we don't need that. Sadly, they don't have they don't have
Bless you.
auto-tune. No, it's not called auto-tune. It's called closed captions. I've been trying to find any court stream for yesterday.
All right, councils. I'm going to
sadly,
mark as the next court exhibit in order an email I received from reports to be drafted by Mr. Weinstein at 11:08 last night. 11.
Code Heidi. Oh, any quote or anything I say, you think, oh, I'm going to use that. Go right ahead. I don't have propriety of that, I think. And I won't assert it either. I'm not even fond of copyright, to be honest. So, unless you actually unless you actually, if you're going to show clips and stuff, just get my name right. That's all I ask for. Let's get this on.
05 last night. Asking the court to inquire about the capability of Dexter Montgomery to testify. Mr. Weinstein, unfortunately, your email is not a best representation of a forewarned judge as a happy judge. Why do I say that? I remember back in the fall of 2022, I ruled upon.
Yeah, Mr. Montgomery is the person who got popped in the head. And yeah, I must agree with the judge here. It's a bit late to bring it up on the day of his testimony. Is he actually competent to testify? It's a bit late. Yeah, that will be a unicorn.
Your objections as to the photographs of Mr. Montgomery. And I ruled at that point in time that the photographs, of course, subject to a foundation, would be admissible to show the extent, as the state asked, of this particular victim's injuries. So I already was on notice as to Mr. Montgomery, and so should you. So my question is, why, as of last night, the first thing, did you then bring this to my attention when you could have brought it to me yesterday, or you could have brought it some other time? And don't give me the for want of belief, because you have just as much of an opportunity to inquire about Mr. Montgomery as the other side does.
You're absolutely correct, Your Honor. There's no reason that I could not have brought this.
So we're working this weekend, right? I guess, right?
Whatever the court orders, I will be available.
Okay.
Your Honor. And I apologize for the late note.
Yeah, this is Mr. Weinstein. And yeah, he did it late. His excuse was he came to the realization. But it was denied. Mr. Montgomery is actually testifying. Let's listen to, I forget his name.
Consistent with the court's order, that she would be here to testify in regards to the Dexter Montgomery incident.
And some other instances to introduce or to attempt to introduce some other evidence.
Well, that notification came out yesterday evening. I believe.
Yeah, from the state, they did tell us. and while we're in court, they said they're going to make a decision as to whether or not CS Tech Montgomery was going to, they were going to ask her to, as well as to go ahead and offer some other instances. So Ms. Love mentioned that in open court yesterday.
Okay, I don't recall that. What I did get, however, at 8, well, it came in at 8:15 on yesterday evening.
She said it was going to be disclosed by 7, so she's an hour and something late.
Well, what I did get at 8:15 on yesterday evening was an email from Mr. Brown indicating that CST Robertson was going to be tested. We were going to try to introduce other photographs, evidence through her, and it listed what those were in regards to specific intrinsic acts. There was also a link attached so that we could be advised and apprised of exactly what.
Remember from the hearing a couple of weeks ago, the judge was adamant that whatever you want to bring in through a witness has to be attached to that witness by the Friday, by the end of business hours for the next week. And what do the prosecution do? They cheat, and the judge does nothing about it.
Exhibits presumably she'd be testifying to. That link was not, I saw this email last night sometime after 11 p.m. It cannot be opened. I'm not aware, and I'm willing to be corrected if anyone else recalls differently, that the photographs were referenced in there. Okay. Somewhere in our discovery that's been served previously, but they're not attached in the link, or well, we can't open the link, so don't know exactly where they are. And so our position would be that we should have been, I don't recall them saying specifically these items or these exhibits were going to be introduced to Ms. Robertson.
I do, sir. I really did. That was the last thing Ms. Love said last night. So subject to a foundation, I'll let them attempt to introduce those, okay?
Well, I would at the very least ask, and I spoke to Ms. Hilton about it a little earlier, that she at least advise us where in the discovery we've been served previously those photographs are, since we can't open the attachment.
Yeah, besides that, when the prosecution sends over, we are using this, they are using a link that they know the defense can't open. Through that link, they know that the defense have issues opening that evidence. And why do they do that? Because they cheat.
Was sent on yesterday.
All right. Okay.
Good morning, Your Honor.
Good morning, Mr. Brown.
As it has been remarked,
I don't care.
Served back in May 23rd, 2023, and it should be in the discovery 11, discovery under Act 16 through 20. And the incident dates are from January 8th, 2015. And
Montgomery, could you please introduce yourself to the jury, please?
And now,
Lieutenant,
Mr. Montgomery is on the stand. Vermont. In my opinion, foul play, bringing this guy on. Complete foul play. And we will go through it.
Parker.
Please raise your right hand. Do you swear affirm and testify which I guess in court today will be the truth and whole truth and nothing but the truth so help you?
I do.
Please state your full name for the record.
Dexter Corey Montgomery Jr.
Can you spell it?
DEXTERMONTGOMERY Jr. JR Corwin CORWIN.
Thank you. Can you slide up just a little bit, please?
Mr. Montgomery, good morning, sir.
Good morning.
Mr. Montgomery, could you please introduce yourself to the jury, please?
How you doing, Dexter Montgomery?
Mr. Montgomery, how old are you, sir?
35.
35. And Mr. Montgomery, do you have a nickname that you go by?
I do.
And what's your nickname?
Who?
Okay. Mr. Montgomery, could you tell the members of the jury why you are here today?
I'm here to seek justice for my injury.
That is not allowed. You are not allowed to ask why they are here to testify. And with that answer, he should have been let out, and the jury should have been instructed to disregard. That is what should have happened. But guess what? Since Judge Glanville doesn't have a spine, he is a fucktard. I mean farquad. It's the accent. I promise it's the accent. I meant to say farquad. It's the accent. Yes, Heather, the state knew exactly what they are doing, and it was predictable. It's predictable because they cheat. They do it all the time.
for my gunshot wound.
Here's the thing. People have already gone to jail, to prison, for the crime that was conducted against Mr. Montgomery. What Mr. Montgomery may not know is that the prosecution gave them plea deals back in the day. He might not know that people actually went to prison for what they did to him. So him seeking justice here? Yeah, I know, Brazo, double jeopardy, but Georgia RICO Act allows for double jeopardy. It's a workaround of the double jeopardy rule. Sadly, it's allowed. I don't know why. Bad rulings from state Supreme Court and the Supreme Court. But here we are. Double jeopardy through RICO is allowed.
And Mr. Montgomery, is this your first time coming to court to talk about what happened to you?
It is.
Now,
And why was that, Mr. Prosecutor? Well, it was because you the prosecution back in 2016, 2015, whatever's, handed out plea deals like poker cards.
Ms. Montgomery, I want to talk to you about your life before you got shot, okay?
Okay.
Okay. Can you tell the jury where you were born and raised?
Say again, sir?
In Atlanta, Georgia.
Hold on.
I was born and raised here in Atlanta, Georgia.
Hold on, Mr. Montgomery, one second. Yeah, come on up.
What the defense is going for here is a prior ruling from Mr. Judge Glanville, where he specifically told the prosecution that they cannot use Mr. Montgomery as a victim's statement witness. What do the prosecution do? They do it anyways. They do it anyways. And that brings us to, for you all completely new here, sidebar counter 135. 135 sidebars in a trial that is, I see it says day 61, but with all the hearing days and half days and breaks and bull crap, we are roughly at day 40. 135 sidebars in 40 actual trial days. Skip ahead. Bahira says that state attorney general needs to step in and turn this kangaroo court around. That won't happen because he or she, I don't have a clue who the state attorney general is, but he or she want to be re-elected too.
Mr. Montgomery, where did you go to high school?
Cobb County.
See, what just happened up on the stand was the judge, despite having ruled on this, went back on his prior ruling. Why? Because he has no spine. He's as much part of the prosecution's team as this guy, who I have no idea who it is.
South Cobb High School.
And did you play any sports?
I did.
What sports did you play?
Football.
What position did you play?
Defensive end.
I'm sorry?
Defensive end.
Okay. I want to turn your attention to the incident where you were injured on April 12th, 2015. Would you tell the jury how that day started for you?
Actually, I was waking up. I woke up. I was in the house. I was in the house. My grandma said she wanted something from the store. So, and I asked her what did she want, and I told her I would go to the store and get it for her. And my little cousin was in the house, and he has a vehicle, and I didn't. So I told him if I can get a ride. I asked him if I can get a ride to the store because we live near the store. Okay. To get my grandma something, what she wanted from the store.
And who is your little cousin?
Cornelius.
Does he have a nickname?
Yes.
Okay. And so where did you reside at that time?
With my grandma.
What area?
The area is known as Lakewood.
And what store was y'all?
The Citgo.
Hello, Brandon. Says, I heard you are doing shots. Is this true? If we get to $50, I will do a spin on the wheel of regrets. If it lands on a shot, then it does. If it doesn't, for you who are completely new here, what is he talking about? What is a wheel of regret? Well, this is a bonus for super chats and gifted memberships. And it looks like this. If we reach $50 in gifted memberships and super chats, I will do one of these. And if we had reached it already, I would have taken a gin shot. So that is the wheel of regrets. It also has wild sauce, wasabi paste, clove of garlic, scorpion sauce. Yeah, stuff like that. But I do have an early work day tomorrow, but yeah, I mean, if we get there, we get there. Let's get back to the trial.
So did Neil come pick you up?
No, he was at the house too. And he was going to, and he had a spot. He had a house near the area, and he was going up that way. So I asked him if he could drop me off to the store on the way up there to get grandma when she needed from the store.
So what's Neil's last name?
Davis.
Talking.
And what's his nickname?
Neil.
Hold on a bit.
So Neil comes pick you up?
No, he was already at the house.
He was already at the house?
Yeah.
Okay, sorry. So you guys go to the store.
Mm-hmm.
What happens then?
She was on the way up to the store, and that's when I got shot. I was in the passenger side. And
so Mr. Montgomery was in the passenger seat of the very car. If you watched me on Monday, who tailed the car with people and a woman and her kids, parked when they got to the gas station, parked a bit behind. And then a few minutes later, made a turn and stopped right in front of. For me, in that neighborhood, that's a very aggressive move. Then they drove to within 20 feet of the white car or tan car, whatever's. And whatever was said, it was so threatening that people showed up with guns. And then they sped off in one direction. The people there got in on another direction. And somehow that dark car made a turn somewhere and met up somewhere else. And then it was shots fired. Brandon, wait, how much is a shot? Well, $50 in total for in super chats and gifted memberships, or if you use PayPal. It's pinned on the top of the chat. We are currently at 15, 20. We are currently at $30. Thank you so much, Brandon, for your support of the channel. So when he is on the stand, now, what happened to him? Did he deserve it? No. Nobody deserves what happened to him. Was it the finding out part of effing around? Oh, hell yeah, it was. No, I don't.
that's when I got shot.
Brandon, I will not adjust.
I was in the car.
That's your choice which venue, but the sum stands.
Do you remember the type of car y'all was in?
Yes.
What type of car was that?
A Camaro.
Was anyone else in the car with you guys?
Yes, but I don't know the name of him.
after you were shot, do you know how, did you go to the hospital?
I did.
Do you know how long you stayed in the hospital?
I don't.
Okay.
I mean, I can't recall. My memory kind of fuzzy. Well, not kind of fuzzy, but
And the wall of... Stop doing that. I turned off all the enhancing thingies.
my memory is fuzzy.
Okay. Were you recently in the hospital?
Paddy B, what is a victim's statements witness? That is usually what happens in the penalty phase, where the victims go up to the stand and talk to the judge to get a harsher punishment. That is a victim's statement. Those are not allowed in the actual trial, but the prosecution doesn't care because they know if they nag the judge enough, he will allow it, as he does now, even though he has a prior ruling that says you can't use him this way. Why? Because Judge Glanville has no spine.
I was.
And why were you recently in the hospital?
Asthma.
Anything-
And seizures.
Okay.
I have seizures because of the gunshot. Now,
How frequently do you have those seizures?
maybe about like a couple every month.
Do you recall anything while you guys were at the Sitco?
No.
No. Okay. Court's indulgence, Your Honor.
Yes, sir.
Mr. Montgomery, do you recall going to the Sitco gas station?
I'm sorry?
Do you recall going to the Sitco gas station?
Do I recall going to it?
Yeah.
Yes.
Okay. And in that time period, from the time leaving your grandmother's house to going to the Sitco gas station, did you have any kind of beef or anything with anyone?
No.
No. Okay. Ms. Montgomery, how do you feel about Neil today?
I mean, he's my cousin. He's my family, so I love him.
Okay. I'm going to show you what's been already admitted as 3 Bravo Bravo. Published in 3 Bravo Bravo now, Your Honor.
It's already been shown, defense counsel?
Yes, it's already admitted.
Okay, all right.
Ms. Montgomery, can you look to your left or, yeah, can you look to your left? Who is that picture of?
Yeah, what's going to happen now is that this is what Mr. Montgomery looked before. Of course, they shows not one of his mugshots. They shows, oh, look how nice he looks. Let's continue.
What am I looking at? I mean, what am I looking for? Right there?
Yes.
That's all they need.
Neil?
Yeah.
Okay.
Oh, it was another one.
And how long have you known Neil?
Shit, my whole life.
Neil?
Okay. Are y'all
Like I said, in my family. So
Okay. Mr. Montgomery, do you know a person named DK?
no,
Do you know a person named OG Bentley?
no,
Do you know an individual by the name of Rodney Allison?
no,
Do you know a person by the name of Walter Murphy? Have you ever had any kind of contact with any of those individuals?
nope.
No further questions at this time, Your Honor.
Cross.
This, I believe, is a mistake. They should have opted out of cross. Just get him out of there, no cross. Because without cross, no rebuttal. Get him out of there. Don't, I mean, all right, let's see here. Oh, all right. Thank you so much, Brandon. Let's go. He just bought 2 spins on the wheel. All right. Bum bum ba. Bum bum ba. Thank you so much for your donation, Brandon. Let's see where it stops. Dun 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 dun. Hey, I can do that. It's a whiskey shot. This is Old Hair. Dun dun dun. Dun dun dun. Cheers and thank you. Oh. Nom, 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 nom. I can do that. And then where's my... Then we set the egg timer for 50 minutes for the next spin. Because if I start doing shots all the time, this stream will end soon. And I know you guys are actually here for the trial and a portion of the legal commentary and some of the entertainment. All right. Let's get back to this.
Thank you, Your Honor. Ms. Montgomery, good morning, sir.
Good morning.
Can you hear me okay?
I can.
All right. Just have a few questions for you, please, about what you just testified to. If I heard you correctly, you talked about the date of this incident occurred back in 2015. Is that right?
Right.
Okay. And if I heard you correctly, your testimony was that you remember on that day that you woke up in your house over in Lakewood, correct?
Right.
And your testimony is that you were at some point going to go to the store to get something for your grandmother. Is that right?
Right.
And you were going to go to the Citgo to get that item for your grandmother.
Right.
Do you recall what it was you were supposed to be getting for her?
No.
Okay. But you do recall that that's where you were going to go and get it from the Citgo. Is that right?
Mm-hmm.
Okay. Is that a yes?
Right.
Okay. You said Neil was at the house.
Right.
And there were other individuals at the house as well. Is that right?
Right.
Now, you got in a vehicle. Is that correct?
Right.
And is it your testimony that you got into a Camaro?
Correct.
Okay. Were you driving the vehicle or were you a passenger?
I was a passenger.
You were a passenger in the vehicle? And you went to the Citgo where you were going to go get that item for your grandmother. Is that correct?
Correct.
Now, do you recall how many people were in the car with you?
No.
Okay. And do you recall anyone in the car having any weapons, any guns?
No.
When you got to the Citgo, am I correct that you never exited the car to go into the Citgo?
Correct. I never even made it to the Citgo.
You never got to the Citgo?
No.
The next spin.
Is it your testimony that this incident occurred, you were shot before you even got to the Citgo gas station?
Correct.
Do you remember exactly where you were when that actually happened?
On Browns Mill.
Muted. Well, that's wrong, Mr. Montgomery. You did not get shot before. You got shot after. After your car sped off, took a right turn, and then went back to confront. Yeah.
Road.
Okay.
Going up Brownsville Road towards Jonesboro Road.
Okay. So you drove from where you were originally, going to Browns Mill Road, correct?
Correct.
And at some point before you got to the Citgo, there was a shooting that left you injured.
Correct.
All right. Deanne.
Thank you, Patty, for the spin on the wheel and Nick suffering through this ride with us. Thank you so much for your super chat, Patty B, for $10. Yeah, I said this last year. I am covering this trial, gavel to gavel. I will be now. They are already missing 3 jurors after 4.5 months. They only have 3 alternates left. If they lose all the rest of the 3, the judge has to make a determination if this is a mistrial and a redo. And if he does, Well, we will have a break, and they need to get a new jury. Will take 6, 7, 8 months, I assume, and then the trial will restart, because this prosecution, unless you change the district attorney, hint, hint, and I will cover that too, because I said so.
Angela White. Who is D'Angelo White?
I have no idea.
Do you recall that at some point after you got out of the hospital, you had an interview with some police officers by the name of Gaither
No,
and Dennis? Do you remember that at all?
no,
Okay. Do you have any recollection of at least Atlanta police detectives coming to your house and asking you questions about the incident?
Thank you, Teddy, for 501. Thank you so much towards the spin. How much for shots and a summary? Oh, oh God. Okay, now the chat has paid for another spin, so we have 2 spins left. Okay, brief summary. In 2022, Mr. Young Thug, Mr. Williams, and 27 others were arrested under a RICO charge for allegedly being part of a criminal street gang, with crimes in furtherance of that criminal street gang under the Georgia RICO Act. Fast forward a year and a half, the prosecution said, we are ready for trial in November of 2023. November of 2022, about 6 months later, they said they were ready for trial. At that point, they had 79 witnesses. Then it took 11 months of pre-trial hearings and jury selections before the trial actually started. So it took them 11 months to actually get a jury. Under that time, from the arrest up until the trial start, they were down to 6 defendants who are still in court, who did not take a plea deal, who did not take, some were dismissed. I believe 6 or 7 took a plea deal that forced them to testify, and others' plea deals didn't force them to testify. And then from, I believe, November 28 until now, it has been a crap show of absolute worthless evidence and testimony. And why is that? Because the Georgia RICO Act allows rubbish as evidence and rubbish as testimony, because the Georgia RICO Act is so broad and so vague. In order for the prosecution to prove in furtherance of a criminal street gang, it doesn't have to be even a verbal agreement, a written agreement, a recorded agreement. It can be unspoken. Ghost 3, am I still green? I have no clue. I would be surprised if I am. Hey, look at that. If you wonder, I do have monetization on, but I choose to not have ads. Ads will be turned on for Replay Crew. When was RICO Act passed? RICO Act, the Federal RICO Act was passed in 1970s, I want to say. The Georgia RICO Act was passed in, I want to say, 2004. Sebastian Miller, what's the sidebar counter at? 135. 135. I meant trial summary, but you do you. Yeah, that's the trial summary. Okay, let's keep going.
Do you have any recollection whatsoever of meeting with anyone at your house and indicating that you had absolutely no memory of anything that happened on that evening, either before, during, or after the incident?
no.
I understand that you don't have a lot of memory about what happened after the incident occurred, after the shooting, but would I be correct that your memory is fairly clear about what happened prior to?
No, you wouldn't be right.
Okay. But you are certain that this incident happened before you got to the Citgo, is that correct?
Correct.
Do you recall prior to getting into the vehicle, whether or not anyone got into the vehicle with any guns?
Nobody. Not that I know of.
Did I hear you say earlier that you are not familiar with the name DK?
Yes.
Do you have any recollection of being asked by anyone with the Atlanta Police Department about DK and saying that you had heard that name before?
No.
At any time after the incident occurred, were you asked to come to court in regards to someone named DK being related to or connected with this incident?
Not that I can recall.
All right, let's do spin number 2. Spin number 2 on the wheel of regrets. Dun dun dun! Oh, wasabi paste. I need to get it from the fridge. Hold on a second. Where is it? Oh God, don't say I left it out. Where's my wasabi paste? Oh, great. It's been out, being warm. Teaspoon wasabi paste. Cami 216. What time is it here? It's 7:15, so 7:15 p.m. Wasabi paste. Up the nose. Full tablespoon? Oh, hell no. Ooh. All right. Back to the trial.
Did you ever had any communication with the district attorney's office prior to the past few months or so?
Yeah, I do. They came to the house
Okay. When was that, recently?
maybe about a month and a half ago.
Okay. No time back in 2015?
No time back in 2015.
All right, one moment, please.
Yeah, that goes more towards the prosecution at the time didn't even care. They handed people plea agreements. The plea agreements were signed, and then Mr. Montgomery was left out of the loop. Now I have this cleared my sinuses. Whew. Yeah, you don't need to see my blow my nose. Starting the
Thank you.
timer.
That's all I have.
All right, anyone else? All right, Mr. Matthews.
No, not more.
Good morning, Mr. Montgomery. My name is Carrington Matthews.
For every cross-examination, they are leaving everything open for rebuttal. They should have just got him out of there.
I represent Mr. Huey in this matter. Back in 2015, 2016, is it your testimony that you were not contacted by any member of the district attorney's office concerning any other case that involved you?
Right.
No one contacted you to talk
No.
about any resolutions?
No.
No one contacted you
No.
regarding
No.
anything?
No. I just said no.
Okay, thank you, sir.
All right, Mr. Sharp.
And the world of doom, stop doing that.
You mentioned a cousin named Neil that was in the car. Neil,
Okay,
is that correct?
correct.
What is Neil's last name?
Davis,
And where is Neil Davis right now?
I have no idea.
Is he in Atlanta?
Yes, I think so.
Okay. All right, thank you. I have no further questions.
Anyone else? Any redirect?
Just briefly, Your Honor. Mr. Montgomery, I forgot to ask you, can you tell the jury where you got shot? What body part?
My head,
Okay. Can you show the jury the portion of your head where you got shot?
right here. Where the dent is. You can see the marks right there, the staples and stitches right there.
Can you kindly turn toward the jury? This way. And can you show the jury where the portion?
Right here, where the dent is. There's no skull there.
And you mentioned you drove it, you guys were in a Camaro. Is the Camaro your memory today?
Yes,
Mr. Montgomery, how has being shot affected your memory today?
it makes me not have one. Makes me.
This is beyond the scope of cross-examination because they didn't ask. But the judge allows it.
It makes my memory go in and out.
And do you remember leaving the sick-go and then getting shot?
No, I told you we didn't make it to the sit-go. Like I said before, we made it.
And he's wrong. He still claims they were shot before they got to the sit-go. And every piece of evidence, then and now, says they were there. Every piece.
To the sit-go.
Permission to approach, Your Honor.
You may, sir.
Mr. Montgomery, may I approach? I'm showing you what's been pre-marked as State's Exhibit 4 Bravo Bravo Alpha and
The old
4
picture.
Bravo Bravo. Do you recognize those photos?
That's me.
That's fair, accurate.
Yeah. And after another sidebar, which brings us to sidebar counter 136. Oh. Brandon Vikings cry too. It's okay. We do when necessary, when called for. We can. Thank you so much, and thank you to Nana Misty for you to take a drink for my birthday, since I will not see you Sunday. Oh, it's your birthday Sunday. Yeah, happy birthday in advance. On Friday I will sing for you, but Sundays are always are always my day off, because I try to do the 7-day-a-week schedule, and no, I need one day completely off. Yes, I'm set. Whenever you think you're here, I say Farquad and nothing else. It's the accent. Let's get on. Well, and after this, and let's see, a few more questions. They show, oh, look how happy he looks. And let's see where it is. And yeah, that's a gunshot wound to the head. So he's missing more or less half his head. On the stand, I believe he has surgery which got his head shape back. And that is the sole reason he was there, to show this. And providing with witness statement. Soon the wheel. Yep. I'm one spin behind, and we are getting closer to another spin.
I think I heard you say, Mr. Montgomery, that the DA's office spoke to you recently or within the past few months about a case. Is that right?
Wrong. You didn't hear me say that.
No?
No.
Okay. Well, let me ask you this. They didn't contact you back in 2015. Is that right?
Right.
Did they ever notify you that the person who was convicted of shooting you, Mr. Walter Murphy, they struck a deal with him?
No.
They never told you that either?
No.
All right. Thank you.
That is a good question. Mr. Montgomery had probably never knew that instead of charging Mr. Murphy, they cut him a deal because of laziness. And he served time, I believe 7.5 years. And Mr. Montgomery never knew. Probably.
Anything further? Yes. All right. Anything further?
No, Your Honor.
All right. And we permanently or temporarily excuse Mr. Montgomery?
Permanently.
All right, Mr. Montgomery, I'm going to permanently excuse you as a witness. You're free to go. Just don't discuss your testimony with anybody except the attorneys in this case. Okay, and thank you for your coming today, sir.
And now,
Then
they had a break. Of course, why not? And then they have a discussion about this testimony, I think. Skipping ahead.
All right, let's get back on record. Sergeant Ingram, all our participants back?
Yes, sir. Vice President.
Okay, good. All right. Can we summon our jurors, please?
Yes, sir.
Oh, did I miss? Did I miss that part?
No, it's a court related matter. Okay, we're gonna need to take up some housekeeping, okay, some physical housekeeping. All right? Thank you, sir.
Where is that part? There it is. Sorry.
Properly granted,
Was the person that noticed that, and we took care of that. So I think we can leave it at that point.
Okay,
About
here
what, sir?
comes the argument.
Mr. Steele, I control certain things, okay, and that's just the housekeeping, okay? The witness here, the seat was soiled. That's what had to be cleaned. Sergeant Ingram is the person that noticed that, and we took care of that. So I think we can leave it at that point.
I wasn't referring, and I appreciate that, thank you, but I wasn't referring to that.
What are you referring to?
Yeah, that was the witness soiling himself on the stand. Now, the argument that Judge Glanville went back on his prior ruling.
The Honorable Court properly granted victim impact exclusion under Waller W.A.L.L.E.R. versus statements been cited previously. I can get you cited if you need. Then I just want the record to reflect, since it's not going to be on camera. When the state called Mr. Montgomery, he came into the courtroom. He was not already seated in the witness chair. And he came in the courtroom, and my word would be shuffled in with a cane type object, like a stick type of cane.
Staff.
A staff, okay. And he sat down with the help of a victim witness / investigator from the Fulton County DA's office, who sits often in your courtroom on the district attorney's side, comes up at times, talks with the district attorney who's closest to the jury. The first question from the honorable prosecutor was something to the effect of, whatever the record shows, tell us why you're here. I want justice for the people who did this. Whatever the quote is, I don't remember, but it's something to that. I then asked to approach. The next question was also victim impact. The honorable court stated that try the case, that leave out victim impact. We appreciate that. And then when we're leaving, when the witness was asked to leave, he was struggling, my view, he was struggling to get up, and he was being helped again by the investigator with DA's office in front of the jury. A juror actually got up and gave room. And I just want the record to reflect all that, because you already ruled
no victim impact, and it was breached, my word would be intentionally by DA's office. And I believe that that goes against what we're doing here.
Okay, since you're crafting that for the record, I'm going to craft what I saw. I saw a witness who had physical limitations come in our courtroom, who was helped by the DA's office and our sheriff's team to sit down. And that was the only thing that I believe that the record should reflect and craft. So,
And to leave.
and to leave. And I think that that would be appropriate for any witness that we have, Mr.
No. In order for a witness to not be more prejudicial than probative, they could have got him in there before the jury was seated and got him out there after you got the jury out. This was an active choice, Judge Glanville. You made that choice because, in my opinion, you are as much part of the prosecution team as any of the three people sitting there right now. You knew, and you made a choice.
Steele. So I'll note it for the record, but I'm just putting on what the court observed. And is there anything else?
The only other issue, the state, I say intentionally violated the court's order to leave out victim impact.
Okay, but I already ruled upon that. So
You ruled upon motion limine granted. They do it. You tell them not to do it. I mean,
but you objected appropriately, and I ruled on it. So
all right. Thank you.
okay, all right. Yes, sir.
So the judge claims he ruled on it, but he actually went back on his prior ruling. Why does he do that? Because he's a fuckfat. YouTubes, I'm saying for quad. It's the accent that gets a bit when I say it too fast. I promise I'm saying for quad, nothing else.
And I was not getting into that other matter, but
I'm sorry?
I understand that.
No, it's fine. But I wanted you to make sure that that there was no other communication with any other jurors. That was, that I control the housekeeping and other things to keep everyone in good health and for your protection. Okay.
Thank you.
Okay. All right. Your next witness ready?
Yes, Your Honor.
Okay. All right. Let's call some of our jurors.
The next witness is something of the most unnerving, has no, if it isn't the cop, if it's the other person, completely useless, has no bearing to the case. But let's just check if it is the one I think it is.
Called crime scene technician Lynette Robertson.
What's her last name, sorry?
Robertson.
Yeah, is the crime scene technician, and what she's going to do is, oh look, a mailbox. Oh look, a car. Oh look, a license plate. Oh look, something from another angle. Oh look, it's a windshield wiper. And what they are, okay, this is an alleged crime scene. There's blood, there's that. It had absolutely yak crap to do with the defendants, as most things in this damn trial. It was unnerving. And yeah, I mean, okay. But none of the defendants had anything to do with it.
Okay. Ladies and gentlemen, the jury, any ministerial inquiry of me?
And then we
Anyone?
have
Okay, all right.
a few
So tomorrow,
commentaries
consistent with our earlier
end of
directions,
yesterday.
we're going to go ahead and have you all report for 12:30 for anticipated 1 o'clock start time. We're going to work about 1 to 5 tomorrow, right? Okay.
It's time for another spin. Dun dun dun. Wheel of regret. Please go more wasabi. Hey, look at that. That's our shot. Yeah, I I can do that. This is sour fisk. It is sour ice pear. It is very sour, but after the sourness is gone, it's kind of pleasant. Just takes a while. Cheers. After the sourness, it's pleasant. Let's get back to the trial.
Okay, anything else with me? Okay, let me review with you your admonitions. Remember, the places I have not given you instructions on how to consider the matter, and we'll do so at the here at the bench. And we covered just ceasing at this point in time before Mr. Brown decided to go into another area. So that's what we covered at the bench. Mr. Adams and Mr. Brown, anything you wish to add or subtract? Okay, all right. That's the sum and substance of our bench conference. Okay, the next thing is a couple things. Please come prepared, as I mentioned earlier. If you have electronic medium, have a printed copy so we can introduce that into the record. Ms. Weaver stays very happy if you do that. Also, continue to send your electronic versions of that same evidence, because we have to have certain things for the assembly of our matters that have been admitted or identified into evidence. Going set minister to. So if you could send them earlier, folks, I know that you as advocates you have to work the task, not the time.
Your Honor, your ruling during the hearings week was attach the evidence to the witness, even things you might want depending on testimony. And you don't, prosecution. Why don't you? Because the judge has no spine, and you know you can whine and bitch for a few minutes extra, and he will buckle.
But please go ahead as much as you can and send it as early as you can so that we don't have these problems. Because if you do have access problems, you can at least go ahead and deal with them earlier than instead of while your eyes are closed. So, all right, that's all I have. Anything else before tomorrow?
Yes, Your Honor.
Ma'am.
Regarding the witness that we expect to be here tomorrow, we are.
Who is?
Other than Mr. Robertson, it is also Investigator Gaither, a former retired investigator, and I called counsel for the defendant.
It's doubtful we'll get through him. We'll start maybe, but okay.
Okay, well, what I'll do, we are having the redactions that were ruled on earlier.
Yes, ma'am.
In some of the other media that we expect to introduce from her. And
Blah,
we
blah,
will
blah,
send
blah,
that
blah.
to counsel for the defendant.
Yeah. All right, folks. We are finally on today. Finally on today. And we are maybe 20 minutes behind. So 1.25. And I will go for about an hour and a half. And because I have work tomorrow, I need a few hours of sleep. So an hour and a half. The rest, because tomorrow will be a half day as well. Friday will be a half day as well. So today, recap plus catching up live. Friday, recap, catching up live. And on Friday, I will have a Finally Friday stream. It's a casual stream where we just hang out and talk about other cases maybe. Maybe you have sent me some fun things you want me to watch, a meme, I don't know. Whatever happens, happens on Friday. So, yeah, but we are here today for this trial.
Okay, Mr. Smith, Mr. Brown, Mr. Atkins, Ms. Love, and Ms. Hilton, good afternoon, counsel. All right.
That's a new one. I haven't seen her before.
All right, counsels, I have several things I'm going to mark as the next court's exhibits in order. One of them is a motion that in limine that was filed in regards to some regarding the redaction of out-of-court statements of D'Angelo White and law enforcement officers filed last night at 9:49 p.m. by Mr. Short on behalf of Mr. Stillwell. I'm also in possession of Defendant Williams' motion to adopt and add Stillwell's motion limine. Filed at filed on 4/17 at 8:39 a.m. I'm also in possession of Mr. Williams' motion limine number 49, which talks about the PowerPoint slide presentation of some 105 pages that references that it's entitled Operation Planners and goes through and has different slides that they're in. Okay,
and here's the thing, motions eliminated filed late. Yeah, because the prosecution, here's something new. Deal with it. And they have to, and then the judge will be mad.
okay, Mr. Shard, have you and the state worked on Mr. White's redaction? Mr. Shard?
Yes, sir. Trying to turn on the microphone.
There you go.
I have spoken to the state about this issue, Your Honor. I identified two different, and we're not in agreement. I've identified two different portions of the tape. Overall, it's about 1.5 minutes that's in dispute. Probably, I believe that there's a hearsay statement at 6:48 of the phone interview. In the car interview, there's just basically what I feel is an argument of future dangerousness that's completely irrelevant, made by Investigator Dennis. These, again, Your Honor, these are on tape statements made by D'Angelo White. Typically in trials, in my experience, prior statements are not just played to the jury. So, but I've noticed throughout this trial that the state, that is the way, their preferred method of impeaching their own witnesses. So if we're going to proceed on that method, which I don't necessarily agree with, I just think we need to clean up those two small areas. One area that has hearsay and one that has inappropriate argument of future dangerousness.
How long have you had this particular recording, Mr. Sharp?
I've had it for over a year.
Why the motion at this point in time then?
Your Honor, I'm not articulating this correctly, I don't think. In trial, we have.
Well, I'm asking.
I'm explaining. Your
I'm
Honor.
asking you because here's the court's.
Again, this judge is incredibly stupid, or he knows he's doing wrong and don't care. Mr. Shard is trying to explain to the judge, we have noticed that the prosecution is impeaching their own witnesses by prior statements they have not shown the witness in preparation for this trial in order for us to look worse. That is why he is now making this motion. It is timely because the prosecution is cheating. Exactly, it's Trinton. He wasn't prepared for the state to cheat and lie this much during the trial. And he definitely wasn't prepared that you, Your Honor, would let them get away with it. Hence, he's filing the motion to protect an appeal. But the judge doesn't care. He's only there to yell at him. You could have done this a year ago. They didn't know the level of dishonesty from the prosecution a year ago.
Here's the court's concern. You could have filed this as a motion months ago.
I wouldn't think that we were going to just.
No, that's not the point. If you think something's going to come up,
I didn't think it would come up.
well, you filed it now, so you obviously because you've identified a course.
I've been sitting in trial.
Mr. Shard, because you've identified a course of behavior. So you should have filed it way before the witness is close to getting on the stand. Do you understand that?
The witness. Well,
let me ask you a question. Let me ask you a question. Do you practice in federal court?
No, I don't. But
I can tell you, this would not happen.
No, Your Honor, this would not happen in federal court because you wouldn't be the judge there. You absolute fuckwat. I'm saying for quad, just with a pitch of voice.
This would not happen.
Okay. Your Honor, I don't think that the statements would be played in totality like this in federal court, quite honestly.
That may be true, but that does not relieve you of the responsibility to timely file a motion and it's just not wait till the last minute.
I'm not waiting till the last minute, Your Honor. I am not anticipating that we're about to discuss a slideshow.
Focus. We ain't got to that yet.
All right.
Focus. I'm focusing on your behavior at this point in time. I'm not saying to you that the information is not any less invalid, but it's the timing that's a problem. It's a problem, and since you
I didn't think that we would be admitting these things, but since I've seen these things, these statements, these out-of-court statements being admitted, I've taken it upon myself. A couple weeks ago, you said to us, please flag things in advance. I took
this
that
is
to
not
heart.
advanced. This is not in advance. This is like we got a jury sitting here. You all didn't get here at 1 o'clock. I told you to be here at 12:30.
I've been here.
I know that you were here early, and I know why you were here early.
Okay.
So, but focus. The focus is on why didn't we file this stuff months ago, and let's wind it out and air it out at that point in time. Okay. So I'm going to ask the state their issue on this. Are you cutting this out? Did you have discussions with Mr. Sharp, madam?
We did have discussions.
When?
This morning.
That's too late. The evidence is excluded. I'm going to exclude because I told you that this was going to happen. No. We're excluding that, and I'm going to exclude the PowerPoint that you all submitted. Well, you're not going to wholesale introduce it.
Wow.
We had no intention.
All right.
We're not here to introduce PowerPoint today. I personally reached out.
And she refuses to sit down and accept defeat because why? I told you numerous times. She knows if she can bitch long enough, she might get the judge to change his mind.
Get a telephone and call at least 2 members of the defense team. Ask them to call me back. And I would like
But you all should not be identifying this stuff the moment of trial while the jury's sitting in a box. This is the last. I am not going to tolerate this any further. If you don't get together with your colleagues and flag issues and resolve them promptly, and if I have to take them up, remember, I can exclude them. We'll work the weekends, or we'll do a combination of both. So this time, I'm going to exclude those 2 sections.
John, Mr. Atkins, he confronted this witness with those sections. I last week let them know that we were introducing that.
If the exhibit's not ready and you haven't made, no, well, Mr. Sharp's got objections to it.
Judge, Mr. Sharp can get in and have our evidence excluded every day that he makes an objection
No.
at midnight, and then comes in and says.
Well, then you all should have gotten your stuff together before then. Some of our juries, please. Some of our juries. Have a seat, madam. Have a seat. You better exclude it. And next time, make sure you're prepared. Make sure you're prepared next time.
Finally. Here's the thing. I don't know what happens today. I have no idea. But fine. And here's the thing. Here is the disrespect from Miss Love. Instead of accepting defeat and move on, she keeps bitching. Why? She's a bitch. And here's the thing. When Miss Love was an assistant district attorney on the prior administration, they pleaded to Fannie Willis to not keep Miss Love on staff. She chose to. And this is the result. Finally, Judge, way too late, is telling her to sit down. And what does she do? I can promise you, if I acted the way Miss Love did in one of my cases, I would have my ass handed to me, and I might have been forced to spend a night in jail. And I don't even do criminal law. I do labor law. If I conducted myself like Miss Love has done throughout this prosecution, I wouldn't have a job. They would have thrown me the fuck out. We are past 2 hours. Let's just check for... oh, I'm still green. I have no idea why. Hey, I'll take the win.
I'm going to do this anymore. I'm just not. We are starting right now. It's 1:20. So
We have talked to them. We have said we don't agree.
then file a motion and get it before me, and we'll take it up. Both of you all have equally responsibility to do that. Oh, it's going to be inadmissible right now.
She keeps threatening.
I'm not going to have any more discussion about this, madam. I'm not. I don't. Well, you know what?
And she
Well, then
raises her voice to
that's why we have to.
Send her to fucking prison.
I'm not punishing anybody, but prior preparation prevents poor performance.
Be prepared, Judge. That's why I sent them last week, a whole week and a half ago, 2 weeks.
I'm not, well,
And I asked, I said, I want you to discuss.
our jury's coming in, madam. Our jury's coming in. Have a seat.
If I think if you ask a criminal defense lawyer working out of the United States, if they had done this to a judge, they would have been thrown out and thrown into a jail cell because they have a prosecution's team. They can still work the prosecution. I am Princess. Was that the prosecutor or the defense lawyer? That's Miss Love, the assistant district attorney who works directly under Fannie Willis. Directly under. Not in a Nathan Wade kind of way. I don't know. Maybe she does. I don't care. Sal, jury heard her yelling, I bet. Wow. They might have. They actually might have.
All right, ladies and gentlemen, please be seated. All jurors present, Sergeant Ingram. All right, ladies and gentlemen, the jury, good afternoon. All right, without further delay, we're going to continue with the presentation of the state's case.
Trying to say our calls, recalls to the stand. Former crime scene technician, Lynette Roberts.
All right, Mr. Brown. Okay. All right, madam, come on up.
Oh, we're going to listen to the crime technician. What's her name again? I don't know.
Ms. Robertson, have a seat. You're still under oath, okay?
All right. Good afternoon, Ms. Robertson.
Good afternoon.
Okay, well, yesterday we concluded the day, and I was going over some pictures as well as I presented you with another state exhibit that we were going to go over. But before we go over that last exhibit, I want to go back to some photos.
We're less than half an hour back.
Starting with state's exhibit.
We will catch up in our
And looking to the right, to the left of you, to my right, or over to the screen behind you. I want to ask you a bit about this particular.
Still about the car?
What are we looking at?
None of the defendants have anything to do with it. I knock it off door.
Yes.
I'll just specific notes. Okay. And what, if anything, do you notice about this hat?
A hat with reddish brown stains.
Okay. And do you see reddish brown stains anywhere else in this photograph?
Yes.
Okay. Where do you see them?
On the ground.
Okay. Where on the ground do you notice them?
By a vehicle door.
Okay. Which door is that?
Passenger side front door.
All right. I'm now turning your attention to State's Exhibit 37, Bravo, Bravo. All right. Former CST Robertson, can you tell the jury what we're looking at here?
A hat with reddish brown stains.
Okay. And is it fair to say this is just a closer view of that last photo in State's Exhibit 30 that we looked at?
Yes.
Okay. I'm now going to turn your attention to State's Exhibit 36, Bravo, Bravo. Just one moment. All right. If you zoom in, just near the actions. Okay. CST Robertson, what are we looking at here?
A hat with reddish brown stains and marker number 1.
Okay. What is a marker number? What is a marker number?
A marker number is marking your evidence.
Okay. And why would anyone use a marker number?
To mark their evidence.
All right. And excuse me, is this item marker number 1 something that you've included in your crime scene record pertaining to this case?
Have to
Sure.
look.
Sure thing.
You asked would it be in my report?
Yes, is that in the report?
It would be in one of my photo descriptions.
Okay, is it listed on the photo description in this report pertaining to this case?
Yeah, this
Yes.
witness is
All
just
right.
there to
Now we turn your
elicit
attention
photos.
to State's Exhibit 91. Bravo, bravo. One more. All right. What do we see in this picture, CSC Robertson?
A picture of, I think, medical equipment on the ground.
Okay. And do you see any reddish brownish stains on any of that such equipment?
Yes.
Okay, where do you see it?
On the ground.
Okay, I want you to, if you could zoom in just a little bit, there's some reactions. All right, and talk down just a bit. All right, for identification purposes, you see it on a blue object or a white object?
A white object.
Okay, all right, no problem. And I'm now going to direct your attention to State's Exhibit 39, Bravo, Bravo. All right? Okay, all right, what do we see in this particular picture?
A photo of street signs.
Okay, and why would you have taken a photo of street signs?
Not only capturing the location, if I was relocated from any area.
Okay, were you relocated in this case that you're here talking about now?
Yes.
And does this picture depict the area to which you were relocated?
Yes.
I ask you, what, if anything, occurred upon your relocation to this particular area as depicted in State's Exhibit 39, the Bravo, Bravo?
Can you repeat that?
Sure, I'll ask it a better question. What, if anything, did you do upon being relocated to the area depicted in State's Bravo, Bravo?
I took photographs.
And for completion's sake, can you describe the street names that are depicted in State's 39 Bravo, Bravo?
Browns Mill Road, Harper Road.
Okay, and excuse me. I am now going to direct your attention to State's 40 Bravo, Bravo. All right. I'm not sure if that box is going to move slightly to the other side. Okay, no problem. CST Robertson, can you tell the jury what we're looking at here in State's 40 Bravo, Bravo?
The intersection of Browns Mill Road and Harper Road.
Is it fair to say that this is just a wider view of said intersection that we looked at in State prior State's exhibit?
The overall view.
Okay, all right. And is it customary for crime scene technicians to take pictures of their relocations to different areas?
Yes.
Okay. All right, I am now going to turn your attention to State's 41. And Ms. Robertson, can you tell the jury what we're looking at here?
Another overall of Browns Mill Road and Harper Road.
Is this the opposite facing angle of the same intersection that you just reviewed in the last State's exhibit?
Yes.
Okay. All right, and I will now direct your attention to State's 44 Bravo, Bravo. Okay, CST Robertson, and if you can zoom in just ever so slightly too. Okay, what are we looking at here in State's Exhibit 44 Bravo?
You're looking at a cartridge casing.
Okay, and is this something that you located upon your relocation to the intersection that was discussed earlier?
Yes.
And is this a piece of evidence that you would have collected upon locating it at that said intersection?
Yes.
And what, if anything, do you do after locating such a shell case?
Once I locate it, photograph it with the marker, process it for latent fingerprints.
Okay.
Let me try to make this a bit more interesting.
Okay, CST Robertson, is it fair to say that this is a closer view of the same shell casing that you located at the intersection of Brownsville Road and Harper Street?
Yes.
Okay, and can you describe the condition of this shell casing that we're looking at here, 645 Bravo, Bravo?
The condition as in,
I'll ask this question. Does it appear to have a dent on the entire way?
it appears that way.
Okay, would you say that this is a spent shell casing or unspent?
I would say it's spent.
Okay, and when I say spent, what is it that I have what is it that you understand it to be?
It was fired, it was used.
Okay, and I am now going to turn your attention to State Exhibit 95 Bravo, Bravo. Okay, CST Robertson, is this the same shell casing that we just looked at in the prior State's exhibit?
Yes.
And in State's Exhibit 95 Bravo, Bravo, is that were you one place that evidence marker there, number 2?
Yes.
Okay, and is this indicative that this was something you collected or taken in evidence?
Yes.
Okay, and I'm now going to turn your attention to State's 46 Bravo, Bravo. Excuse me, 47 Bravo, Bravo, my apologies. Okay, CST Robertson, what are we looking here at State's 47 Bravo, Bravo?
A cartridge casing.
And is this a different or the same cartridge casing that we looked at in the prior State's exhibits?
A different one.
Okay, and as with the last cartridge casing that we discussed, can you describe the condition of this particular shell casing that we're looking at in State's 47 Bravo, Bravo?
Spent casing.
Okay, and I'm now going to turn your attention to State 52 Bravo, Bravo. And if you're just zooming in ever so slightly, so that you get accuracy. There we go. Center, please. And CST Robertson, can you tell the jury what it is that we see here? Is this the same shell casing?
The same shell casing as the last photo, yes.
Okay, and that evidence marker, is it fair to say that evidence marker that is placed there is indicative that you took that shell casing also?
Yes.
And with both shell casings that you collected in this particular case, is it also fair to say that you ran tests on both of them?
Yes.
And what was the test that you ran?
I processed for latent fingerprints.
And did you find anything of value?
No.
Okay. And I'd like to ask you, did that conclude your involvement with this particular APD case number, which is APD 151022458?
Is this right here?
Yes, as to this particular APD case number, APD number 1510224.
Yes.
Okay, no problem. Thank you. And I am going to now. I am now approaching no time. Already provided discovery process and pre-market 62 India, Your Honor. Your Honor, I'm not approaching Ms. Robertson, excuse me, with Stacy to the 62 India. Ms. Robertson, I have now handed you Stacy to the 62 India. After having a second look at it, I'll ask you a question.
My report from another shooting incident.
Okay, and how do you know what it is?
I'm looking at my report.
Okay, and has your report been changed or altered in any way since the first time, since when you altered it on January 9, 2015?
No.
Okay, Your Honor, at this time, the state now moves to admit states 62 India into evidence.
Any objections?
Imagine being crime tech. These things have already been through the justice system. People have gotten plea deals. You have moved on to other more current crimes that you might preparing for to testify about. And instead, you are being called back for 8 to 10-year-old stuff. What a fucking waste of time. Hi, Brandon. Thank you for your $5. How much 2 more spins? Oh, now I have to calculate. Hold on. Oh, I think I wrote we were 23 from, and with yours, we are 18.
Stacy India, say 62 India. Let's ignore the last one until it's if it's admitted. Can I see it, please?
Yes.
Maybe, I mean, we've seen Judge Glanville make an effort to be impartial, and then he forks up. Maybe for at least this day, he will make somewhat impartial decisions.
All right, Mr. Adams, I'm going to overrule your objections. State 62 India is admitted.
Of course. And here we go.
All right, Ms. Robertson, and Ms. Robertson, I'm now approaching you with state 62 India, and I'm going to ask you a few questions. Based on your report, what day were you called out for service?
January 8th,
Okay, over here.
2015.
Okay, so this is earlier than the incident that we just got through discussing that occurred on April 12th of 2015.
Yes.
Okay, what time did you get called
Even
out?
as an underlying act? I don't know.
11/24.
Okay, and is there an APD case number associated with this particular incident on your report?
Yes.
Okay, and what is that APD case number?
It is 150-083
130.
As was the case yesterday, if you would be as kind to mark the poster board with that date under the appropriate month and year, or month and day. That case number. Your Honor, I should advance. The witness have continued permission to move about courtroom.
She may, sir.
Thank you, Your Honor.
Have you hit the like button yet, you who are here now? If you haven't, please do. It
And it goes without
makes me
saying,
break
if
through the
any defense
YouTube
seeks to locate
algorithm
themselves,
if
take a
I
look
have
or
as
have another
many
vantage point, you're
thumbs
welcome to
up
do
as
so.
possible.
Okay, thank you.
Thank you.
Okay, I'm going to now direct your attention back to state 62 India. Can you tell the jurors, the members of the jury, the location to which you were initially called out as it pertains to this particular APD case?
675 Metropolitan Parkway.
Okay. Is that the address that you were first positioned at when you arrived at that crime scene, or is there ever a time that you relocated during this particular incident?
It's possible I relocated.
If you would be as kind to turn to the narrative portion of your report and read what it is that you noted at that day and time you took.
We are only 20 minutes behind.
On January 8th, 2015, CSTL Robertson was called for service at the location of 1064 Metropolitan Parkway for an aggravated assault. I took photographs of the vehicle and of its damages. I was relocated to 675 Metropolitan Parkway where incident took place. I took photographs of another vehicle and of its damages. I collected 7 shell casings. The 7 shell casings were submitted into the APD crime lab for further processing. See attached photos. No further requests were made.
All right, so I'll ask you now again, since that you had an opportunity to read the report. Was there a time that you initially, was there a location to which you initially responded?
Yes.
And was there a second location within that incident that you were there to process that you responded? I'll refer to Your Honor. Can you tell the jurors today what addresses you responded to for this particular case?
1064 Metropolitan Parkway.
Okay, and what was the second that you read?
675 Metropolitan Parkway.
Okay, and in what county are those locations located?
Fulton County.
Okay. And when you responded to the first address, can you tell the jury what, if any, evidence you collected at that time?
Photographs and I believe vehicle damages, photographs of the vehicle damages.
Okay. And when you responded to the second address for this incident, can you tell the members of the jury what, if anything, you did at that time?
At the second location, I took photographs. I took photographs of the damages to vehicles as well as collected shell casings.
Your Honor, at this time, the state is now approaching the defense with state's exhibits 1 India to state's exhibit 61 India, which have already been shared in the discovery process and have been remarked.
Jesus Christ, this is boring. I will assume that this shooting has nothing to do with any of the defendants, as most, if not all, of the other things. Skip ahead. It's not
I'm now approaching you with state's exhibits 1 India to 61 India, and after you've had a chance to look over those, I kind of actually looked up at me and I'll ask you some further questions. Okay, I see you looked up at me. Does that mean that you finished everything?
Everything?
All right, no problem. Okay, and what is it that I've handed you as states exhibits 1 India to 61 India?
Repeat the question.
I actually can. What have I just handed you that's been pre-marked as states 1 India to 61 India?
Photographs of crime scene.
Okay, do you recognize those photographs?
Yes,
How do you recognize them?
I took these photos.
All right, and have those photos that you looked at been altered in any way since the day that you initially took them?
No,
They fairly accurately depict the location of the crime scene that you responded to on the day on the day of January the 8th, 2015.
yes.
Okay, Your Honor, at this time, I now move to admit states 1 India to states 61 India into evidence.
Any objection to states 1 India to 61 India?
No, sir, no, sir.
All right, they're admitted, may be published as you see fit.
Thank you, Your Honor. Ms. Robertson, I'm going to turn you back to your crime scene record that pertains to this particular incident that you responded to. That is the noted as states exhibit 62 India. And I'm going to turn you to the page that pertains to the photos descriptions that you listed here through 1 through 61. And I would ask that you would kindly read what it is that you did, your photos correspond to in this description.
Are we starting with photo number 1?
Yes, so I'll direct you. Yes, until you.
Photo number 1, close-up of street signs. Photo number 2, overall, let me back up, of the Chevrolet vehicle. Number 3, mid-range of back of vehicle. Number 4, close-up of vehicle tag. Number 5, overall of driver's side of vehicle. Number 6, close-up of front of vehicle. Number 7, overall of passenger side of vehicle. Number 8, overall of back of vehicle. Number 9, overall of rear window damage. Number 10, mid-range of rear window damage. 11, close-up of rear window damage. 12, overall of passenger side rear window damage. 13, overall of passenger side rear window damage. 14, mid-range of passenger side rear window damage. 15, close-up of passenger side rear window damage. 16, close-up of passenger side rear window damage. 17, close-up of vehicle VIN number. 18, overall of location. 19, close-up of address. 20, close-up of address number. 21, overall of name of location. 22, overall of back of vehicle. 23, close-up of vehicle tag.
I'm trying a new tune. A little bit more Nordic.
24, overall of driver's side of vehicle. 25, overall of driver's side of vehicle. 26, overall of passenger side of vehicle. 27, overall of passenger side of vehicle. 28, overall of rear window damage. 29, overall of front of vehicle. 30, overall of rear window damage.
Hey, I'm green again.
31, mid-range of rear window damage. 32, close-up of rear window damage. 33, close-up of rear window damage. 34, overall of shell casings. 35, overall of shell casings. 36, overall of shell casing. 37, close-up of shell casing. 38, mid-range of shell casing. 39, close-up of shell casing. 40, overall of shell casings. 41, mid-range of shell casings. 42, close-up of shell casing. 43, close-up of shell casing. 44, mid-range of shell casings. 45, close-up of shell casings. 46, overall of shell casings with markers 1 through 7. Overall, 47, mid-range of shell casings with markers 1 through 7. 48, overall of shell casings with markers 1 and 2. 49, mid-range of shell casings with markers 1 and 2. 50, close-up of shell casing with marker 1. 51, close-up of shell casing with marker 1. 52, close-up of shell casing with marker 2. 53, close-up of shell casing with marker 2. 54, mid-range of shell casing with marker 3. 55, close-up of shell casing with marker 3. 56, mid-range of shell casing with marker 4. 57, close-up of shell casing with marker 4. 58, mid-range of shell casing with marker 5. 59, close-up of shell casing with marker 5. 60, mid-range of shell casing with marker 6.
All right.
You want me to 61?
Yes, ma'am.
Close-up of shell casing with marker 6.
Okay. I'm now going to turn your attention back to when you relocated from 64 Metropolitan Parkway to the 675 Metropolitan Parkway address. Upon relocating to the 675 Metropolitan Parkway address, how many shell casings did you recover from that location, according to your report?
Can I take a look? According to the report, 7 shell cases.
According to your report, can you tell the jury, were fingerprints done on these shell casings as were in the case of the first AP case I was responding to?
Yes.
Okay, and was anything of value found from those shell casings?
No.
And in your report, as it pertains to the window damage that you noted, when you say damage, what kind of damage are you describing?
Defect damage from shootings.
Okay, and based on your report, how many vehicles had defects?
2.
Okay. Do you know anywhere in your report where those vehicle types were?
Yes.
Okay, can you tell the jury what those were according to your report?
Look real quick. Chevrolet Silverado and a GMC 150.
Okay. And as it pertains to this particular case, after did you in fact collect those 7 shell casings that you observed on at the 675 Metropolitan Parkway address?
Yes.
And what was done with those shell casings that you have?
I collected them and processed them for like fingerprints and turned them into the APD crime lab for further processing.
And did that include your involvement with APD case number 150 to 150 to
150-0083130.
Yes.
Okay, and I am now going to turn your attention. I'm now pushing the defense with what has already been remarked as states 23 Foxtrot, and has already been served in this one process time.
And now they are going to show more evidence. Apparently, this crime technician is busy with crime technician stuff. I wish he could have testified in a current crime-solving thingy that actually made a difference on the street. It made a difference on the street of Atlanta.
Foxtrot. Miss Robertson, take a look at it. What it is that I've just handed you. 125. Once you're done reviewing it, please look up at me.
And asking, and then they are looking at more pictures. Oh. That is the beginning of cross-examination. Finally! Come! I'm going to bring that down to 1.25 because cross-examinations always better than the prosecutions trying to whatever they are doing. Come on, Mr. Adams.
Robert, good afternoon.
Good afternoon.
You hear me okay?
Yes.
On the microphone, Mr.
I've
Adams.
got a couple questions for you in regards to what you just testified to previously, okay? I heard you correctly, you were a crime scene technician.
And of course, we're World of Doom. And Brandon is here again. I am a slightly challenged towel bead. Thank you for letting us know, Brandon. And that brings us to... We are $13 away from the next spin of the Wheel of Regrets. Sebastian Miller cross is always better, but then again, that depends on the case, on the defense and state. Yeah, I've seen horrible cross-examinations. The Hannah Gutierrez retrial that just concluded, whoever that lawyer is, I wouldn't hire that lawyer if my life depended on it.
Back in, I'm going to start first with the April 12th. April 12th, 2015, you were a crime scene technician with the Atlanta Police Department. Is that true?
Yes.
You were called out to a location at Fremont. I think you said 1987 Fremont. Is that right?
Yes.
And of course, you were not involved in the initial investigation. You came there specifically for the purpose of collecting evidence. True?
Repeat that.
All right. When you came to the location as a crime scene technician on April 12, 2015, you were there to document and collect evidence. True?
Yes.
Because that's what you were doing at that point. That was your role, correct?
Correct.
Okay. So you get to the location, and the only thing that you know is that there are things at Fremont, this Fremont location, that you've got to document and take pictures of, correct?
Correct.
All right. Now, you're not a detective, right?
Right.
You wouldn't be charged with talking to individuals, correct?
Correct.
The only person really you'd be interacting with would be either the detective or the officer that's there to see, telling you what items you should focus on, correct?
Correct.
That notwithstanding, did you actually talk to anyone at the location when you got?
Objection calls for hearsay.
Objection calls for hearsay. Yeah, somewhat valid. Thank you, Brandon. I'm trying on to reshoot this with Apple, but if they don't fix it. What? Super beds? Well, we're just $3 away. So the wheel of regrets for you, Brandon. You got a discount. Wheel of regrets. Dun 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 dun. What do you make me do? Vodka shot. I can do that. And here it is. It's called Nemirov. And I believe it is a Ukrainian vodka. Dun, dun, dun. This is a part of the entertainment. If you super chat, gifted memberships, or PayPal me enough, I will do one of these. Cheers. Yep. Oh, that was good. We just got to make in time for Wheel of Regrets. Yay! And back to the trial. And we are at cross-examination.
I stand objection.
Well, I'm not asking when was I'm asking if did you speak to anyone on that day when you got there?
Yes.
All right. Would it be just officers, or did you speak to lay people, to regular citizens?
Officers.
Okay. So you spoke to no laypersons when you got there, just police officers, correct?
Correct.
All right. Now, when you got to the location, and then you saw pictures earlier of the vehicle that you photographed, there was no one in the vehicle, correct?
Correct.
Police officers had been there already, true?
True.
You didn't have any idea whether the incident that left the defect in the front of that vehicle happened at Fremont or happened at the other location of Brownsville. You didn't know that. Objection, Your Honor.
Brandon, are you typing with your elbow? Can I type you a sentence, Lisa? I don't know what you mean, but thank you so much. Amanda Louise, wait, does Nick's name in yellow mean something? Well, my name in yellow? Well, if you write at something, my name to me shows up as yellow in the chat. Maybe it does that for other people as well. I have no idea. Sorry.
Stand objection.
Did you know where that defect, where the vehicle was when it got that vehicle? Call for speculation.
I stand objection.
Why? That's actually not. She is a crime scene technician. She can answer, I don't know. That's not speculation. That's a weird sustained objection. So I guess whatever we saw earlier about Mr. Glanville putting Miss Love on her ass, well, that's gone. Now he's back to his usual things.
All right. When you got to Fremont, the vehicle already had a defect in it. True?
Yes.
All right. Now, I want to ask you specifically.
The World of Doom. I've been streaming for a good while now, and sometimes it acts up a bit because my memory is full. I don't know why, because I have 64 gig of memory, but maybe it's a cache, whatever it's called. I don't know. My computer skills are on. That's about it. My nephew is the computer whiz. Well, he isn't, but I still call him, and then he tells me if something goes wrong. Well, you only need to do this, and then he goes on a 5-minute technical thingy, and I'm you lost me before you started to speak. Okay, wait until tomorrow, and I will solve it. And then he shows up and fixes my computer for me.
About some of the things that you were tasked to do. when you started the Fremont location, you ultimately ended up going back, or going, not back, but going to the corner of Browns Mill and Howard, is that right?
Browns Mill and repeat that?
Did you end up going to a different location after Fremont?
Yes.
Okay, what was that second location that you went to?
I'm gonna tell you the exact location. I was relocated to Browns Mill Road at Harper Street.
Okay, and that was at the direction of a law enforcement officer?
Yes.
With the state's assistance, I want to pull up some of their photographs that were shown earlier. You have those? Let's start with
Speeding up again.
I want you to take a look at that when it's on the screen for us, okay?
I have about 30 more minutes, then I have to go sleepy, go nana. Because I have my alarm bell tomorrow morning goes off at 4:30 a.m. and it's currently 8:30 p.m.
Do you have your reports in front of you, Ms. Robinson?
Yes.
That's it, okay. All right. Robinson, I want you to take a look at the screen and tell me if that is the scene that you looked at earlier and described as the front of a vehicle, or the vehicle that you photographed. Is that what it is?
Yes.
All right. So when you get to the location, you see this vehicle, and it is exactly as it looks right there, correct?
Yes.
You didn't open the doors.
No.
You didn't put that hat on the ground.
No.
You don't know how it got there.
No.
You don't know who had it on before you got there.
No.
You don't know how it got on the ground.
No.
Now, there was no one in the car, right?
Correct.
And you looked through the car. You searched it, right?
Correct.
You didn't find any guns in the vehicle.
No.
You don't know whether there were any guns in the vehicle before you got
No.
there. Because you came there after the fact, you don't know if there were any guns in the vehicle. True?
True.
You are not in a position, because you weren't there prior to this scene, to say how many people were in the vehicle before that. True?
True.
You don't know how the vehicle got from Browns Mill to the Fremont location, right?
Right.
Let's look at 27 Bravo. 27 Bravo, right next to you, Roxy, is the front of the vehicle that you photographed, is that right?
Photograph of the windshield defect.
The windshield in front of the vehicle, right?
Correct.
Now, of course, by the time you got there, that defect is already there, right?
Yes.
You don't know how it got there. True.
True.
You don't know what was happening at the time that bullet went through that windshield, right?
Right.
Because you got there at this point, where you looked at the vehicle, you don't know what anyone inside of the vehicle was doing at the time that bullet came into the vehicle.
No.
You were asked a lot of questions about whether or not the window, the driver's side window and passenger side window were either up or down. Remember those questions?
Yes.
In these photographs that you were shown, the windows appear to be up. True?
True.
Right. Now, it is fair to say that since that's the position they were in when you got there, you don't know whether they were down sometime before that, right?
Right.
You don't know who, if anyone, manipulated the windows at any time before you got there. True?
Objection. That's not evidence. Sustained objection.
That's not evidence.
Sustained objection.
Seriously, Judge, this is a crime scene technician, and he is asking her about her observations and what she can reasonable conclude. That is not speculation. That's her actual job. This is weird, but I'm not surprised.
Do you know whether the car was ever at Browns Mill and Harper?
Repeat that.
Do you know whether this car that you photographed was ever at the corner of Browns Mill and Harper?
No.
And so you wouldn't know whether or not it traveled from Browns Mill and Harper to Fremont, and if so, how we got here, right?
No.
Can I see a 15 Bravo? 15 Bravo Bravo that you're looking at over to your left, Ms. Robinson, is this vehicle with what appears to be what you described as bloodstains on the ground, true?
Yes.
Bloodstains on the interior of the car, correct?
Yes.
Bloodstains on the door, the passenger door of that vehicle, right?
Right.
Now, when you show up as a crime scene technician, you can collect evidence, right?
Right.
But there's certain things that evidence can tell you. You agree?
Right.
Evidence can tell you, for example, whether or not it appears as though a gun was fired inside the vehicle. For example, if you find shell casings, that might be an indication that the gun was fired in the vehicle, right?
Right.
Or it might not. Gun may have been fired, there just are no shell casings in the vehicle, right?
Right.
Gun could be fired from a revolver, where there's no ejection of the shell casing, and then you don't see any shell casing in the vehicle, right?
I'm going to object, Your Honor. This is facts finding evidence. I stand objection.
You didn't find any shell casings in the vehicle, right?
Right.
But that doesn't tell you whether or not the gun was fired in the vehicle or not, correct?
Correct.
The photographs that you take, the items that you collect, they're not, that evidence isn't capable of telling you who's in the car, right?
I wouldn't know who would be in car, no.
Right.
It would be sent to the lab to confirm.
Right. You wouldn't know what anyone was doing in the car, right?
No.
You would know the motivations of anyone in the car at any point, right?
Right.
That's a cause for speculation. I stand objection.
I mean,
Let's move on, sir.
crime scene collection can assist in collecting physical evidence, right?
Right.
What it can't do is pass upon the motivations or actions or the reasons that people in this car may have done what they did, right?
Right.
Objection. That's not evidence. Motion to strike.
Motion to strike.
I stand objection, Mr. Adams. It's an improper question. Ladies and gentlemen, don't disregard the last question. Let's move on, sir.
Were you ever tasked with going to the Citgo gas station on that evening?
What's the address for the Citgo?
Well, did you go to the Citgo gas station, regardless of what the address is?
I don't know. I don't recall.
You don't know, you don't recall.
I don't recall.
Were you ever shown any video surveillance from a Citgo gas station?
I don't recall.
Hello, Mr. Jingles. Do you want to be cuddly? Do you want to be cuddly?
39.
Hello, Mr. Jingles. Ow. No, ow. Please be cuddly, Mr. Jingles. I know you're not a cuddly. Ow.
That's the location that you went to after you left the Fremont address, is that right?
Yes.
What's the distance from the Fremont address to,
We need to show you to the audience. Ow, ow.
I don't recall.
Look out. Look how happy Mr. Jingles is.
Did you say yes or no?
He is so happy. Look at that
Did you make a notation of the distance between
glorious
the Brownsville and Hawthorne
smile.
location to the Fremont location anywhere in your report?
Ow.
Nothing located in my report about that.
So you went there because one of the officers of the Texas Court go there and take some photographs, all right?
Correct.
Do you remember who the detective was or the officer was that you were dealing with that night who was giving you the instructions on?
I don't recall.
That's not evidence.
Can I have a 41 Bravo? Photograph that you're looking at right now, Ms. Robinson, that's the Brownsville and Harper location, is that right?
Yes.
Now, as you were taking photographs of this intersection, did you know what the significance of this related to the vehicle that you were taking photos of earlier?
You said, did I know what?
Yeah.
Repeat that one.
What's the significance, right, of this intersection you were taking photographs of?
So shooting and some cartridge casings.
Okay. Were you of the opinion or were you of the knowledge that it was a shooting that had taken place at this location?
I was relocated to this location.
Someone just one of the officers, whoever was told you, go to Brownsville and Harper and look at photographs, you're fine.
One of James' characterization calls for hearsay, Your Honor. I'll stay, Mr. Horn. You can rephrase your times.
Jesus Christ, Judge.
Let's see, 45, probably. All right, shell casing, 1 2 found that location, is that right?
Thank you, Your Honor. Second, sir.
Objection made.
What's the standing objection? You can rephrase.
Okay. The shell casing that is depicted in State's Exhibit 45 Bravo is a shell casing that you took a photograph of, is that correct?
Correct.
You took a photograph of 2 shell casings, is that right?
Correct.
This is one of them, right?
Correct.
This is one of the two photographs, the two shell cases that you took photographs of, right?
Correct.
You don't know anything about, well, I heard you say that they were analyzed for fingerprints.
Yes.
Did you do that?
Yes.
And were the results made part of your report?
Yes.
And they were negative for fingerprints, is that right?
Correct.
And so other than finding two shell casings at that location, there was nothing else of evidentiary value related to these two shell cases, correct?
You have my report, but it's correct.
Yes, yes.
You have my report, yes.
Well, you remember what happened when you examined the scene and took photographs and stuff like that, right?
No,
It is
because
good
I don't recall. You have my report, and I can answer your question. You give me my report.
Okay. So in order to tell us anything about that night or your investigation, you need to
Refer to my report. Yes,
you
correct.
don't have the independent recollection of it, right?
Hold up, Jack, brother, that's an answer. Hold objection.
What about evidence of any blood at the location? And when I say location, I'm talking about Harper and Brownson. Did you find any indication of any blood there?
No.
No independent recollection. Yeah, that is what you get when you call witnesses a decade later. And yet some of the cops claim they have almost spotless recollection of what a crime scene looked like and stuff like that. Well, that's because the prosecution goes through the testimony with them just prior, so they can sit on the stand and act as if they actually remember it.
Any cameras at that location? Traffic cameras? Anything like that?
I don't recall.
Were either you or anyone else with the Atlanta Police Department who was investigating this crime, the shooting that night, tasked with checking to see whether any homes right near that intersection may have had any cameras, ring cameras, anything like that?
I'm sure the detectives did.
You sure that they did?
Yeah.
Okay. Do you know for a fact that they did?
No.
I think you did not, right?
No.
So the crime tech didn't collect.
There were no witnesses at the location at Harper and Brown's location that you would have interacted with.
True.
They should be going on a break soon, because I have 20 more minutes before I actually need to go to bed. Slightly intoxicated. Thank you, Brandon, and the rest of you for supporting my channel and making me do stupid things via the Wheel of Regrets, which you will see again on Friday.
You recall, and I'm not sure whether you can, if you can't see it from this photograph, I want to just ask you based on what you remember from that night, if you remember, whether or not the front passenger window was slightly open or slightly cracked when you got there.
According to the pictures, it was slightly down.
You have a 91 Bravo, bro.
Yeah. For you who don't know, I'm going to the United States in August. One of my stops is Atlanta.
Let me ask you something.
I will try to make it inside the
As
courtroom.
crime scene technician, if items are taken from
I will not be
individuals
out of
at a crime
place
scene,
at all in Atlanta.
would those items ultimately end up in your possession or would those go with someone else?
Can you repeat that?
Yeah. At a crime scene, and that's you generally now, this is in your experience as a crime scene technician. At a crime scene, let's say there's an individual who is connected to a crime scene, and let's say a gun is taken from that individual. Would that gun then be turned over to you?
Yes.
In this case, when you arrived at this location, there were no items retrieved from anyone that were turned over to you, right?
Right.
When you got there at the location, the person who was shot, the person was already gone, right?
Yes.
Okay. Any other individuals around?
I don't recall.
In 91 Bravo, the picture of the back of the car, right?
The ground.
Right. If you're looking a little bit further on the car itself, looks like the door is closed, right? You know what I'm talking about?
Yes.
Driver's side, front door closed, right?
Yes.
Was this picture taken before the pictures of the interior or after?
I don't recall.
Who closed the door?
I don't recall.
Was it closed when you got there, or was it closed after you got there?
I don't recall. What does the picture say?
So when you testified earlier, when we showed you the picture of the car with the doors open, and you said that's the way the car was when you showed up, you don't really recall whether that was the case or whether the doors were closed, do you?
I don't recall.
Okay. Fair to say that in order for a door to be open at one point, close at another point, somebody has to close the door, manipulate the door, right?
Objection, characterization. I stand objections.
In order for a door to close, if it's open, someone has to close it, right?
Yes.
In order for a door to open, if it's closed, someone has to open it, right?
Yes.
This is interesting. If you caught it, in another crime scene photo, that very door there was opened. Who closed it and why? Because when she is on the scene, nothing is supposed to be disturbed. Nothing. And yet, the door is closed. Isn't that weird? It's almost as if the investigators at the place do not care about the people collecting evidence.
The personnel I'm seeing when you were out.
Not that I recall.
Oh, Nana Misty has to go. Thank you for being here, Nana. Thank you for the gifted memberships. Thank you so much.
It is true that.
See you again on the Friday.
Right?
Yes.
The car was located at this 1987 Fremont location, true?
Yes.
You don't know how or if it got from, or why it got from the Harper and Brownsville location to Fremont. You don't know that, right?
Objective, ask and answer. I stand objection.
You don't remember whether or not the door was open or closed when you got there, true?
Objection, ask and answer. I stand objection.
All right. I'll move on and ask some questions.
So it's allowed for the prosecution to keep nagging the same point over and over again. But if the defense asks what she was ambiguous about, asked and answered. Sustained. Yeah.
About the incident that you talked about, Metropolitan Park.
Mr. Adams, can we pause right now? Ladies and gentlemen, want to take a comfort break?
Oh.
Okay, we're gonna do that, Mr. Adams. You can resume as soon as we're done. All right, ladies and gentlemen, let's take 15 minutes, okay, and then we'll come back. Madam, I'm gonna excuse you as well, okay? 15 minutes to come back, all right? All rise.
All right, folks, that is a natural break. I'm tired as fuck. I'm slightly intoxicated. Thank you, Brandon, and the rest of you for super chats and gifted memberships and everything. As I said, since they're only doing half days this week, next recap and getting up to speed, up to live Friday, and tomorrow there is an update on the Rex Hoyerman case, the alleged what's it called? Damn. Gilgo Beach serial ender case. There's been an update. He was in court today. So tomorrow I will do a recap of the Gilgo Beach endings and Rex Hoyerman, who is the prime suspect and is held without bond, of course. So that is tomorrow. Friday, Young Thug recap plus live, just as today. Friday afternoon, US time. Finally Friday. And the return of the Wheel of Regrets. All right. Thank you all for being here. Thank you for allowing me to try to translate this trial to you with legal commentary, with snark, with yeah, everything in between, and alleged name calling and stuff like that. Thank you. I will be sending you over to Megan Fox. Megan Fox is doing the Tonsil Twins, the woman who claimed she got pregnant via a BJ. That's interesting. But thank you all for being here. Over at Twitter, over at Rumble, here on YouTube. Thank you so much. And hug your family. Unless your family's crap, then screw them and give your love to the people who deserve it. Okay? Thank you for being here. See you tomorrow, Friday. Thank you. Bye-bye.